My lord, on behalf of Mr. Ramdas Acharya, I may be permitted to make a small mention. My lord, today's item number 226 in weekly list. My lord, this same matter was listed last week also, but it did not reach the board.
What can I do?
My lord, I anticipate that this matter may not reach today also.
Okay, we'll get ready. We'll hear. Take on this matter.
Weekly list item 133, Lordship Belgium, NDPS matter, custody since 16/1/23, Lordship convenient time, Lordship pray for convenience.
It's there in the list. Why are you mentioning it? Yes.
Item 145, my lord. I'm sorry, I am through virtual mode.
Yes, sir.
Item number 145. He is in custody for 5 years. I have filed an application for interim bail. My lord, can take up any time today.
All right. Yes.
My lord, this is a weekly list 237. It is a maintenance case, my lord. It came in the several
serially,
but it could not reach the board.
Item 69 and 95 in process. Item 69 and 95 of this weekly list, my lord, that is in process, my lord.
Just
69 and 95, my lord.
69, the Land Council for the petitioner submits that the matter has become infructuous, accordingly disposed of. Another is 95.
Yes, my lord.
Item number 118, my lord.
95, same order, infructuous. Yes.
118, my lord, serial.
Infructuous?
No, my lord.
Then?
Last Friday, Mr. Das made a mention, my lord.
Yeah.
Your lordship directed to take the matter at 2 p.m. But the OPID council could not get the file. So matter has been adjourned.
Okay, we'll see.
This may be taken up, my lord.
Okay.
Matter has become infructuous.
Which one?
Weekly list 11.
11, same order, infructuous. Okay.
My lord, item number 237, it is a maintenance case. Last time also it came, but it could not reach the board.
See that, yes.
Supplementary.
I don't mention, my lord.
One mention, my lord.
I don't mention, my lord. Item 258. It's a check bounce matter lingering since 2016. Last week I have also mentioned, my lord.
That is the application, my lord, against the interim application rejected. I have filed the mother illness, serious illness, my lord, for which, my lord, your lordship can
yes, any memo?
Yes, no.
For interim mail, my lord.
Give it.
210, man. 210.
Pardon to mention, my lord.
210 only interim application.
See that after lunch.
18, my lord.
Pardon to mention, my lord. Item 258, my lord.
Item number 1 call.
Pardon to mention, my lord.
Supplementary list item.
Mention, my lord. My lord, CRL number 2560 of 2022. The petitioner is a 85 years destitute widow mother, my lord.
Give your memo, yes. Yes, item number 1.
Please, madam. Last time I am giving this. For the loss. Miss Bobida Sahu is appearing for the central.
Yes. Yes, Mr. Tripathi.
Yes, my lord. Letter has been sent and the copy also sent to the Tahsildar, but no instruction received, my lord.
Tahsildar Balianta.
Yes, my lord. On 7/7/23.
Get his personal appearance next week. The Land Council for the state submitted that after receipt of the order dated 7/7/2023, it has been sent to
on very day, my lord.
Tahsildar Balianta for verification of the documents of two bailers on the very day. And No response has been received from the Tahsildar Balianta. Let the Tahsildar Balianta appear in person before this court on 4th of August 2023, along with the instruction sought for in the order dated 7/7/2023. Free copy of the order be handed over to the Learned Council for the state for compliance.
Obliged.
Hmm? 200?
46, sir.
What is your name?
Sukhand Nitiraj Kishore Mansingh, sir.
What do you want?
Sir, I want to withdraw.
What is your identity proof that you are the person?
Sir, Aadhaar card is with me.
Pass on, pass on. Why didn't you ask your advocate to make such a mention?
Sir, actually, since long time, he's not been cooperating with me.
Any order has been passed against you?
Yes, sir.
What order has been passed?
Actually, the marriage dispute has been dissolved by the Honorable Court.
Because now both the sides of the advocates are not there. Suppose some order has been passed against you. 246. Let the Learned Counsel for the petitioner files a memo to withdraw the bail application disposed of as withdrawn.
Item 2.
May I please, my lord. I have handed over the copy of the depositions, my lord. Out of 9 witnesses, my lord, so far 6 witnesses have been examined, and only 3 witnesses, they are the official witnesses, and the informant was examined as PW2.
What is the offense here?
Offense, my lord, 302 and other offenses, my lord. 302, 16, 18, 20 unlawful activity prevention act.
No, you have handed over the deposition copies.
Yes, sir.
Anybody has stated anything?
No, star witness turn hostile.
Who is that star witness?
One PW4 eyewitness.
PW4?
Yes. Chittaranjan Nala and PW2 also informant.
You are in custody since when?
Since, my lord, in fact, my lord, in other cases 2012, but they have shown that I have been custody since 2021 in this case, my lord. But I was in custody since 2012, my lord. In connection with other cases, and in all the cases I have been acquitted, my lord.
Your earlier bail application was rejected by me.
Rejected, and you are also directed to expedite.
That is in that 3465.
Yes, my lord.
देखिए order 3465 order again.
I have annexed, my lord. That is annexed to page 22. There is one antecedent similar nature. In other case, your lordship is directed to release me.
The Learned Counsel for the petitioner, Learned Counsel for the state. The Learned Counsel for the petitioner submitted that the petitioner is in judicial custody since 15/3/2021, and he has been charge sheeted under section 147, 148, 302 by 149 of the Indian Penal Code and sections 16, 18, 20 of the Unlawful Activities Prevention Act stop. It is further argued that when the petitioner approached this court first time for bail in BLAPL number 3465 of 2021, as per order dated 26/10/2021, the same was rejected. However, the petitioner was given liberty to renew the prayer for bail after examination of the eyewitnesses in the trial court. The Land Counsel for the petitioner submits that in the meantime, six witnesses have been examined, including the eyewitnesses, but they have not supported the prosecution case. They have not stated anything against the petitioner. And in view of the change in the circumstances, the bail application may be favorably considered. Land Counsel for the petitioner has produced the certified copy of deposition of the witnesses, giving copies to the Land Counsel for the state which are taken on record. Land Counsel for the state, after going through the evidence of the witnesses, submitted that PW2 and PW4 are the two star witnesses on behalf of the prosecution, but none of them has stated anything against the petitioner. However, he submits that the petitioner has got one criminal antecedent.
Yes, so similarly.
Considering the submission made by the Land Counsel for the respective parties, the period of detention of the petitioner in judicial custody, since witnesses examined so far, including the eyewitnesses, have not implicated the petitioner in the crime in question, for the taking into account the period of detention of the petitioner in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail allowed.
Obligement.
Item 3.
Item 3, I am for the petitioner, my lord. This is fourth round application. Your lordship must see the last order. Comprehensive affidavit already has been filed and served copy to the state, my lord. My lord, the petitioner is in custody since last 4 years, 10 months and 11 days, my lord. Your lordship
No, you have got criminal antecedent, that to 9 in number, and you are required to file an comprehensive affidavit.
I have already filed. It is in the file, my lord. On 19th July.
And have you given a copy to the Land and State Council?
After serving copy, I have filed.
What infructuoso you have mentioned?
My lord, that is 110 CRPC, my lord, 3 months undertaking to give for peacekeeping.
Now, no, this particular case is one under section, the main offense is 376 AB.
No, that is not.
Yes, the present case.
6 POCSO. Yes, this case.
That is why I am telling you.
This case is not infructuous.
No. This particular case is one under section 376 AB. Right? Notice is sufficient.
Yes, ma'am.
So what happened to the victim?
Victim PW3 Miller. Out of 21 witnesses, my lord, 11 witnesses examined. I have given
PW3
deposition report.
Just.
Yes, Miller.
No, not PW3.
Witness 2.
PW2 আছে। What is the date of custody?
My lord, 10/9/2018, my lord.
What is the status now?
My lord, out of 21 witnesses, 11 has been already examined. I have given the deposition report. Others are not yet come and appeared, my lord.
Okay. Mr. Tripathi,
Yes, my lord.
this man is a local man? No. It's a man from
UP, my
UP.
lord, staying at Jharsuguda, working as worker.
No, working as worker, you will fade away.
His sister is staying there, my lord.
His sister is not. Mr. Tripathi, take instruction about this particular address, which he has mentioned as permanent address in the district Pratapgarh, whether it is correct or not. And additionally, he will give me the documents of 2 local sureties to you for verification. The Learned Counsel for the petitioner submitted that the petitioner is in judicial custody since 10/9/2018, and he has and out of 21 charge sheet witnesses, 11 witnesses have been examined. As per the order dated 7/7/2020, যেটা সব পারাগ্রাফ লিখিবে, the Learned Counsel for the petitioner has filed a comprehensive affidavit relating to the status of the cases pending against the petitioner. Copy of the same has already been given to the Learned Counsel for the state. The Learned Counsel for the state pointed out from the cause title that the petitioner is a man from Uttar Pradesh, and therefore he may be given some time to obtain instruction whether the address furnished in the cause title is correct or not. Let the Superintendent of Police Jharsuguda make necessary communication with the Superintendent of Police Pratapgarh in the state of Uttar Pradesh for such purpose. The Learned Counsel for the petitioner shall also give the name, address, and documents of 2 local sureties who are interested to take the petitioner on bail to the Learned Counsel for the state, which will be verified through the IIC of Jharsuguda Police Station, and report be produced on the next date. Free copy of the order be handed over to the Learned Counsel for the state. List this matter. 2 weeks ପରେ ଯୋଉ ଶୁକ୍ରବାର ଆସିବ ସେଇଦିନ ଆସିବ।
Supplementary.
Yes, obviously. So, address verification, documents of sureties to be verified. Okay.
Item 4.
My lord, on the
Helmet of the wife of the petitioner. Medical documents have been filed. You have sought for instruction.
Yes, on those, sir.
Yes, Mr. Counsel, the instruction has not been received. The London State Council wants it next week, so it will come on 28th of July, next Friday. The Land Council for the state 1 week time to obtain instruction as per the order dated 7/7/2023. Is this matter on 28th July 2023? Okay.
Much obliged.
Item 8.
Certain what's the next date posted for framing of charge, because the input orders rejecting a discharge application indicates that 15/7/2023 was the date for framing of charge.
Yes.
Thereafter, it was shifted to 17/8/2023 for framing of charge.
Consider
Charge has not been framed.
Yes, charges have not been framed.
Yes. Now,
My lords, my main case is, my lords, if your lordship sees, FIR was lodged on in 2003, sorry, 5, exact date. FIR was registered on 5/6/2007. Charge sheet was filed on 4/12/2009, and cognizance was taken on 25/2010. Till date, trial has not started, my lords. A long period of 17 years have passed, my lords. And this petitioner, who was an assistant engineer then, is stagnating in the post of executive engineer. And one of the main allegation against the petitioner, to satisfy your lordships that on facts also he has an excellent case, my lords. I'm not only on delay in the trial, my lords. My lords, the vigilance department did a check measurement after 3 years of the actual execution of the work, my lords. That is on if your lordship sees, the date of commencement of the work was 17/5/2002. The Vigilance Technical Wing conducted a check measurement on 19/9/2005 after 3 years, my lords. This is a flood-prone area.
19/9/2005.
17/5/2002, the work commenced. And on 19/9/2005, there was a check measurement of that area. And it was, according to the Vigilance Department, discovered that a sum of rupees 25 lakhs has been misappropriated. There's a shortfall of work commensurate to the tune of 25 lakhs, my lords. My lords, if your lordship...
No, Mr. Let us first... if you say you are also harping on delay of commencement of trial. So the law is very clear. Suppose you are responsible for the delay, obviously it cannot be a ground.
Lords, it cannot.
So if you want to say that I have no way responsible for the delay, then I am to verify that order sheet itself. Have you got the order sheet with you?
The entire order sheet?
Because after the submission of charge sheet,
yes,
till today, suppose any stay order has been passed at your instance or anything like that.
No stay order. If your lordship wants, we will give the entire charge sheet.
Because you are taking that ground, and
yes,
there are some decisions are also there that the case can be quashed because of this
long delay.
Right, that is there. But for that, I am to satisfy.
Yes, my lord. Certainly, my lord. What your lordship is saying is perfectly correct, my lord.
Mr. Have you got any instruction, any stay order or anything, or any delay-dallying tactics on behalf of the petitioner is the responsible for the delay? What he says that till date even the charge has not been framed. What is the question of and you have also taken instruction charge has not been framed. So if the case is of the year 2000, what is the
2007
FIR is dated
5/6/2007.
So obviously at least 16 years have passed in the meantime, right from the date of lodging of the FIR, and charge sheet is dated.
Charge sheet is dated
2009.
4/12/2009.
So if that date is taken into consideration, it becomes about 12 years, more than 12 years is there. So that is one of the ground he is taking. So for that, he is to file the certified copy. Certified copy of order sheet.
Entire order sheet I'll file before you.
To show that no, you are not responsible.
Yes.
The other thing you say that the work commenced on 17/5/2002 when it was completed as per the prosecution case.
My lords, this was done during the pendency of the work. I'm coming to that also.
No, you said that the check measurement was
done. Check measurement was
on
done
19/9/2005. No, suppose
by that time the work had not been completed.
Then how he found
exactly that is also my case, my lords. As per the terms of the agreement, every payment made to the contractor, there were up to that date, my lords, this particular date, my lords, there were 9 running account bills. And every payment made to the contractor will be treated as an advance. The final settlement of accounts will only be with the final bill.
Right.
Final bill has never been executed, and 48 lakhs remains with the department. Suppose 25 lakhs extra he is also taken. Then that can be settled with that 48
adjusted lakhs. That can be adjusted later on.
Yes, well. So the final because ultimately if in the final settlement of accounts, amounts have been misappropriated, then they can charge me that you have misappropriated these amounts or you have given the extra payment to the contractor. But if final settlement of accounts as per clause 6, my lords, at page 65, I'm just replacing that clause.
No, suppose, Mr. It's a construction of a road.
Construction of a road.
Let us say that 1 kilometer road.
Yes.
And it is fixed at the rate of that, let us say 1,000 rupees. Let us take for example. You have constructed up to 500 meters. Out of 1 kilometer, you have constructed 500.
Yes.
And you have been paid, let us say 800 rupees.
800.
So you are to, as per that agreement, you are supposed to get 200 rupees more. But you
Yes.
are to complete the another
Entire.
500 meters.
Exactly.
Right. So
He has completed the work.
Huh.
Final bill has still not been paid to him. 48 lakhs remains with the department. So how can there be a misappropriation? 28 lakhs, even let us say, my lords, it's not commensurate with the work which has been executed. Then, my lords, again, my lords, that is why exactly, and 7% of the bills are being deducted to find out if any discrepancy arises, that will be adjusted. That is there in the clause itself, and it is being deducted. So how can there be any extra payment to the contractor at that stage?
Right. Yes,
that is my case.
Das, what is your submission?
Lords, I've got. Am I audible to Lordship?
Yes, yes.
Lords, I've got the materials which are produced before the Lord trial court, particularly indicating the exact completion of the petitioner in the act of in that particular misappropriation, and more particularly for accepting the substandard work, two, recording of false and implanted measurements, and three, Milords, another junior engineer who is the overall supervision work, Milord, he has in fact tampered the measurement book page number 23, 24, 68, Milords, and Milords manipulate the entries and which have been accepted, Milord. So far, the petitioner's specific complexity, Milords, I'm placing one line, Milords, of price, Milords.
Which page?
Milords, one Bikram Lenka, Milords. He is the assistant engineer. What he says, Sambhuji Acharya, JJ, Milord, who is the Milords, who laid the foundation of this kind of RD section has measured the entire work in which payments have been made. See, Santosh Kumar Sambal, the petitioner for Lordship, Notes, the assistant engineers has check measured the work up to 5th array, and then another A, Prakash Kumar Ball A, has check measured the work up to 9th array, and the last person, say Suvendu Sekhar Mahapatra engineer, has passed the bill up to 8 RMs. This is a complete Lord. They, in fact, the three persons, one is Sambhuji Acharya, with a junior engineer, who
that means that was
they work in a tandem, Lords, in the part of conspiration, Lords.
That has been completed.
And to show extras, Lords, to show undue favors to this particular person, namely Ramesh.
Just a minute. Mr. Kanungo.
Yes, sir.
He says that suppose it is divided in like 7A, 8A. So you are to get on completion of 8A, you are to get this much. What he says, that entire work, of course, has not been completed. But since this was the condition and you have completed up to 8A.
But extra payment of 25 lakhs.
And you are supposed to get a particular amount. You have been paid more than what you are required, what you should have been given. That is one part. Extra payment, that is they say. But extra payment is not cannot be said to be a misappropriation. Because
I'm going back to your lordship's example. 1 kilometer road, he has completed half. I have paid him 800 rupees, let's say, my lords. So, if at the time of completion of the road, I pay him another 800, then I misappropriate or I have given extra payment of. But if I pay him 200.
If suppose another example maybe, suppose I showed that I have completed, this is the road I have completed and the cost is actually, let us say 1,000. But it was check measured. And it was found that it would be around maximum would be 500 rupees cost. So that can be said that yes, I have given an exaggerated figure. So rest amount of 500 I have misappropriated. But it's not a case of that nature.
No.
It's a 8A, what they say that up to 8A you have completed, and up to 8A you are supposed to get, let us 1,000, but the department you have
has paid 1,500. But 7% is being deducted.
But the work is in under progress. So if anything extra has been paid, that means that 500 can be adjusted subsequently.
Because your lordship is aware of a long line of decisions that the final bill is the final settlement of accounts. in the middle, and the clause specifically states that these are to be treated as advances. It is not for actually commensurate with the work done.
But one thing he says about the substandard work, that is also the allegation again.
Substandard work, my lords,
Inflated
after 3 years, if
measurements,
they check.
inflated measures, or tampering of measurement books.
But that
All
is
these
done by
have been
the if at
accepted.
all. That is done
Accepted,
by
and they
the
facilitated
assistant engineer.
this particular payment, excess
Yes, sir.
payments in a bid to show undue favors to this contractor.
What is the
And
what is the exact role played by
Yes,
entire
no,
thing?
exactly.
Don't mix everybody's accusation against him.
Against him, my lord, the specific allegations, my lord, the
What was the he? What was he? The petitioner.
The petitioner, assistant engineer,
Assistant engineer. So as per your case, what is the role of an assistant engineer
assistant engineer, Lords, he after that particular Sambhuji Acharya, Lords, did all the entire misfigures and
ordinarily JE makes the check measurement.
JE in fact laid the foundation of this particular episode, Lords, and he tempers, changed the calculate and change for which there is error in calculation, and as manipulate the entries, all those things, my lords, and my lords, check measured by
no, not in the. I just want like this. Give me that. This is the specific, as per your chart sheet. This is the role of the JE, and in this particular manner, he has not done his duty, or so far as the misappropriation of a X, let us say, this is the role of, if you would have pointed out this defect, the payment would not have been paid. Let us say, check measurement has been done incorrectly.
To facilitate the contract.
Right, that is exactly. To facilitate Mr. X to draw money, ultimately they will get the benefit from that money. This thing has been done in connivance. If that is your case, right, if that is your case, suppose after JE's check measurement, the stamp of approval has been given by this assistant engineer, and
and the executive engineer release their excess payment.
Executive engineer makes the final payment after
Subhendu Sarkar.
Right, whatever it may be. So, what role has been attributed against this, and what are the heading? That means one is you say check measurement is wrong. Number two, you say substandard work, like this. So where that portion is there,
accepting the tampering made by the Sambhuji.
Tampering what? Tampering what?
Lots the figures in that MB measurement books on page number 23, 24, 68 have been tampered and changed for which there is error in calculation and his manipulated entries. These things have been also accepted in one suite by this particular petitioner gentleman and another assistant engineer who did the ninth RM lots.
Right, Mr. Kanungo, you also prepare that according to their case, what they have alleged exactly against you.
Yes.
Then we'll see that whether the ingredients of the offenses under which charge sheet has been submitted are made out against you or not.
And also I'll place the order sheet, Malos.
That order sheet. It's a 420 charge sheet has been submitted, and so obviously cheating is there, misappropriation 409 is there, and forgery is there, criminal conspiracy 120B is there, apart from 13 to 13-1. So, okay. All right, heard Mr. Milan Kanungo, Land Senior Advocate, appearing for the petitioner, and Mr. Sangram Das, Land Standing Counsel for the Vigilance Department. The first contention that was raised by Mr. Kanungo is that the first information report in this case was lodged on 5/6/2007 relating to the occurrence which has taken place in between 2001-2 TO2 2004-2005, and the investigation, on completion of investigation, charge sheet was submitted on 4/12/2009, and even though in the meantime more than 12.5 years have passed, the trial has not commenced. That is your instruction. And therefore, on the ground of delayed disposal of the trial, the case is, the proceeding against the petitioner should be quashed. The Land Council for the petitioner seeks some time to produce the certified copy of the entire order sheet to show that the petitioner is no way responsible for the delayed disposal of the trial stop para. Mr. Sangram Das Lanin, Standing Counsel, has produced the case diary and submitted that the petitioner was the assistant engineer, and several charges has been leveled against them, including tampering of records, incorrect check measurement.
He accepted the tampered made by that Sambuji Jain.
Acceptance of the
Tampered measure
record.
books.
Acceptance of the tampered measurement books, number one.
Accepting substandard words.
Accepting the substandard work.
Accepting the inflated measurements.
Accepting the inflated measurement, etc.
And payment of excess money.
And payment of extra amount to the contractor. And he will make a detailed chart of the same, and the supporting evidence, both documentary as well as oral, to substantiate such accusation. Prepare a note and hand over a copy of the same to the Mr. Kanungo in advance. List this matter. So let it come 1 week after. That means let it come on 4th August 2023.
Well, 4th August, I think, Your Lordships, we have the election case.
I see. Election case has been fixed to, okay, you don't want it on. Then it will be on 11th. Okay, on 11th August 2020.
Not 11th. 10th?
No, it is a hearing day. This Wednesday and Friday.
4th also in the first half, because
which one?
Election 4th, because election case will be at 2.
There is absolutely no problem. So 4th August 2023. All right.
Deeply obliged.
Item 11.
For clarification, I want to bring certain facts before your lordship's kind attention, because this criminal division was filed by the 2 petitioners. They also filed 2 other cases that has been tagged in the present case. In 2 other cases, earlier cases, the cognizance order was challenged. That is a case relating to PMLA Act, under which cognizance was taken on basis of the complaint petition filed by the enforcement director, and notice was issued. While the pending such matter, in the complaint petition, allegation was made that the schedule offences were there, referring a particular case registered at Chhatrapur PS, and that case was subsequently taken up by the CIDCB Orissa for investigation, and charge sheet was submitted. That is the basis, along with the other allegation. I am not confining that only schedule offence the proceeding was initiated. Thereafter, what happened, my lord, that proceeding was challenged before this honorable court, and ultimately the honorable court quashed that criminal proceeding, which was duly accepted. So far the schedule offence is concerned, that was no more, and that has been quashed. Thereafter, my lord, a petition said to have been filed on section 227 CRPC. Before going that, I candidly say that whether a 227 proceeding petition can be maintainable or not before appearance, that is a question. But however, a petition was filed under 227 CRPC on behalf of the petitioner before the designated court. And in that case, the
counsel appearing on behalf of the enforcement director filed an objection. And after considering that aspect, without going to the merit of the case, the learned court below observed that it is not maintainable. On the ground, I am not saying that it is a wrong order. On the ground that the accused persons has not yet entered into appearance, and as per the law, it is to be session trial procedure is to be followed while adjudicating the matter. In view of that, a revision has been filed. My suggestion in this case for better adjudication that all the matters should be taken up together.
It is listed today also.
Yeah.
It is listed today. No, all these any matter has been left out, Mr.
No. All the matters should be had together. So it will be better because as I have already stated before your lordship that so far the criminal revision is concerned whether it is maintainable and the court below is rightly passed the order or not. I am not sure that the court below committed any error. I will prepare a chart and place it and copy to my friend. So it will be more facilitated for adjudication of all the cases. That is my submission.
No, tell me just both of you tell me that what date I will just if you are not ready today with the notes and please give in.
Received the copy of revision petition.
No, he will hand over the copy.
Yes.
And also Mr. Mahapatra says that a short note will also be given
to my senior.
All right.
One matter has been left, my lord. Connected matter CRLMC 1757 of 2019.
Wait. CRLMP.
MC. CRLMC number 1757 of 2019.
2019
2019
এটা হচ্ছে এটা কানেক্টেড আচ্ছা মিস্টার অগ্রওয়াল কাହାର কপি পাই নাନ୍ତି না কাହାର
ক্রিমিনাল রিভিজন যেটা টপরে
প্রথমটা পাই না এই দুইটা পাই
পাইছে
Okay, Mr. Gopal Agrawal, Land Counsel, appearing for the Enforcement Director, submits that another matter, that is CRLMC number 1757 of 2019, is connected to this petitions, and therefore it may be listed along with on the next date. He further submits, you mentioned this in first one, that CRLV, further submit that he has not received the copy of the revision petition. Mr. Sorchand Mahapatra, Land Senior Advocate, is present and submits that copy of the revision petition will be handed over to Mr. Agrawal by next week or by next week, and he intends to prepare a note of argument along with citations and supply the same in advance to Mr. Agrawal. On consensus of both the parties, list this matter. Kebe rakhiwa kuhନ୍ତୁ?
Relate my inconvenience to my senior.
4 ତାରିଖରେ ରଖି ହବନି ସେ ଛାଡି ଦେଇକି ନା 11 ତାରିଖ ରଖି ଦଉଛି କାରଣ 4 ତାରିଖ
I have a humble prayer before parting to say,
yes.
If a motion will be made before the designated court, he will adjourn the matter because there is a
I don't know what date is fixed and for what purpose. You say that now the 227 petition has been rejected. So obviously the
appearance ହେଇନି
ସେଇଆ କହୁଛ appearance ହବ ଆଉ trial ତ ପ୍ରଶ୍ନ ଉଠୁନି
trial
ତେଣୁ ଆଉ stay
ଖାଲି appearance ପାଇଁ ସେ warrant କରିଦେବେ ନା ତେଣୁ ମୁଁ ଗୋଟେ
I submit one thing, my lord. After rejection of that order, 2-3 dates were granted. Now on 6th July, a 205 application has been filed, which is pending.
So again that will be
yes.
Again that will be rejected. He will come here or whatever it may be. So
that
let us
be hard. We have to file.
Okay.
ତାକୁ ଯେହେତୁ matter is pending before my lord.
Okay.
ସେ ତାକୁ ମୁଁ prayer କଲା adjournment.
All right, Mr. Sorochandra Mahapatra, Land Senior Advocate, submits that the petitioner may be permitted to move an application for adjournment of the proceeding in view of the fact that the case is now posted before this court on 11/8/2023. Mr. Ograwala, on the other hand, submitted that on 6/7/2023, a petition under Section 205 CRPC has been filed by the petitioner for dispensing with personal appearance, and a copy has been received, and they intend to file objection to that petition, and no such interim order is required to be passed in the present revision petition. In view of such state of affair, please this matter on 11th August 2023. Yes.
Item 2.
Yes, Mr. Bhavani Shankar Das Parida.
Item 2, Lordship, kindly be taken off 1 week after.
May I submit one thing, my lord? In this case, my lords, the petitioner has challenged an order rejecting a discharge application at page 35, Lordship, reports that impugn order indicates that the case has been adjourned to 26/4/2023 for framing of charge. But I got the instruction that in the meantime, charge has been framed on 1/5/2023. Let my learned friend verify this one. In that event, my lords, if he so advised,
1/5/23.
1/5/23. Let you verify.
You take down the date.
Yes.
If the charge has been framed in the meantime, you have approached this court against the rejection of your discharge petition.
Yes, sir.
If the charge has been framed, then you have to amend the petition.
Yes, sir.
That certified copy of framing of charge also you have to get it and file an interim application for amendment of the prayer portion, and may take some ground also. All right,
Yes,
take down the Mr. Sangram Kumar Das, Learning Standing Counsel for the yes.
I only is das.
Acha, Mr. Sangram Das, Learning Standing Counsel for the Vigilance Department, submits that the petitioner Sudhanshu Sekhar Swain challenged the order dated 19/4/2023 passed by the Learning Special Judge Vigilance Dhenkanal in TR number 3 of 2019 in rejecting the petition filed by him under section 239 of CRPC for discharge. And from the impugned order, it appears that the case was posted to 26/4/2023 for framing of charge, and he has received instruction that charge has already been framed since 1/5/2023.
Let petition verify.
The Learned Counsel for the petitioner seeks some time to verify the same, and if necessary to file an application for amendment challenging the order of framing charge, if any. Put up this matter in the on 11th August 2023.
Item 3.
Please.
4, my lord, I pray for next week, my lord.
Next week means
Or any day.
28th. All right, Mr. Sharma, Land Council for the no interim order has been passed in this.
No,
case.
no, for the first time it is now.
What defects, Mr. Sharma? Defects, if any, be removed in the meantime.
Right.
28 8 28 7 2023. All right. Mr. Sharma,
Yes.
the defect that has been pointed out is that it is to be registered as
CRLA.
CRLMC. So you have to file an interim application to change the nomenclature then.
So next day I'll come
Okay,
with this
okay.
case.
Item 5.
May I please, ma'am?
Yes, Mr. Panda.
Bailor verification. This is second time I've given sureties.
Outsider.
My lord, outside.
You have handed over all the documents to him. Yes, Mr. Mishra.
Yes, my lord. Instruction has come that none of any members showed their willingness to file bail petition on behalf of Rakesh Kumar. That it is ascertained from inquiry and reveals that the actual Aadhaar card number of Guru Harijan, one of the bailers, is such and such. Photocopy of the same enclosure for your kind perusal. But in the Aadhaar card docketed in the Honorable Court is such and such, which is totally different from each other.
No, it's all right, but they are not interested to take the petitioner on bail.
And yes.
Okay, so that goes though. You have to file a fresh one.
Yes.
All right. Though the Learning Council for the
And the other one, the second one is not residing in the village.
I will file fresh.
The Learning Council for the petitioner state submitted that instruction has been received on the local sureties to the effect that one of the sureties is not interested to take the petitioner on bail and the other surety is not residing in the village. In view of the submission made by the Katu Pile instruction
OIC
from the
Muduli
from the OIC na IAC of Mudulipada police station. The Land Council for the in view of the submission made by the Land Council for the state, the Land Council for the petitioner submit that he will file the names, address, and documents of to fresh local sureties, giving copy thereof to the Land Council for the state for verification. If the documents and the details of the sureties are furnished, Land Council for the state shall obtain instruction on the same. Please this matter. Give a date. Yes.
Okay. My lord, 4th or 11th.
No, it will come on 11th. Give it because it requires some time to. Yeah.
Item 6.
My lord, item 6, the status report was called for. It is in flag 1.
Accused Indradev Prasad alias Yadav defaulted, non-bailable warrant of arrest has been issued.
Well, that is my bail is 10664 of 2020.
Now the case stands to so and so for production of the absentee accused Indradev Prasad alias Yadav. That is one thing. Next thing is proposes to examine all the charge sheet witnesses. Summons were issued to the witnesses for their evidence. In the meantime, 2 witnesses have been examined out of 23. So that is the position. One of your associate has fled away he was released on bail by this court, interim bail. You are man from Jharkhand. So again another will go. You furnish your details to the. Have you verified the address?
No.
Address verify karantu. Local security diyantu. Thoda so verify bole kon.
Madam, one more prayer. One IA number 922 of 23 I have filed. मतलब the cause title टिके भूल ही जाइथिला मु सेटा फाइल करछि सेटा टिके लॉर्डशिप में काइंडली कॉल.
But which one? Yes, Mr.
मतलब the cause title address given in the bail application has been wrongly typed. I have filed IA number 922 of 2023.
काई सेमती किछि आई अछि देखिले?
नहीं सेटा आसीनी मतलब.
केते नंबर?
मतलब 922 of 2023.
सेमती किछि आई आपण पार अछि कॉपी?
No.
All right. The learned counsel for the petitioner submits
मतलब I have served the copy on the state. I have got the receipt.
that an interim application has been filed by IA number 922 of 2023 for correction of the cause title, the address furnished in the cause title, address of the petitioner as furnished in the cause title. And the copy of the same has been served on the London State Council, to which the London Council
I've got the receipt.
Put up this matter on such and such date, give a date. In the meantime, the Land Council for the petitioner shall furnish a copy of IA number 922 of 20. All right. The yes or the copy furnish the names, address, and details of the local sureties, including their documents, to local sureties who are interested to take the petitioner on bail. The Land Council for the state submits that the petitioner is a man from state of Jharkhand, and he may be given some time to verify as to whether the address furnished in the cause title is correct one or not. Set up कर दियंतु तापरे IA टाकू so better that IA first come for correction, otherwise you will.
मतलब I have served the IA and consolidated cost title also served, madam.
List this IA 922 of 2023 on गोटे week पर पकई दियंतु 28 रे 4 तारीख पकई दियंतु. So it will come with that IA.
Yes, madam.
922 of 2023. I am not directing to verify the address at present, because that address is to be corrected by in this IA. Then you will take instruction, okay? But he will give you the local sureties, so that if he gives that, you can take instruction. No, he okay, then yes.
Item 7.
Yes, Mr. Mahanti.
Please, Lordship. Lordship, in this case, Lordship, last occasion, Lordship directed to take to standing counsel to take the instruction in which case he has been released on bail and which case he has pending and which case he has been acquitted. And in this case, Lordship, petitioner is custody Lordship 26 January 2017. And it is a remand case, Lordship. In other cases,
26/7.
26/2017. And in this case, Lordship, all the other accused persons are already been released on bail by the Lordship BLPL number 3415 of 2015 and 1427 of 2015 and 479.
Your bail application was earlier rejected several times. All these BLAPL indicates that. How many times your bail application has been rejected?
No, it's the first bail application.
First bail application. Then what is this number which you have given?
2852. My bail application number is.
नहीं ता सहित जो आसीची ना उइथे कि ना ये थोड़ा आसी
हाँ सेटा
सेवडा का आपण कर नुहे
ना मोर सेटा न ସେଟା co-accused ମାନଙ୍କର ସେଥିରେ ସବୁ bail ହେଇଛନ୍ତି
Okay,
ସବୁ।
okay. So that means it's an old case
Yes, sir.
where you are shown as an absconder in the charge sheet.
Yes, sir. Yes, absconder. Therefore,
अरे
arrested
एक केस टा होची 2010
Yes,
मसीहार
yes, sir.
FIR is
FIR
dated
is unknown.
22 ओके लाजे 22/2/2010
Yes, sir.
तो चार्ज शीट के बेला
Charge sheet ଅଛି F6 dated
charge sheet is
22/2000
no that is charge sheet is dated 9/1/2016
9/1/2016
CSLR 9/1/2016 okay and a charge sheet has been submitted in your name and also the name of the co-accused person.
Yes, Lordship.
Okay. So you are charge sheeted and you were taken into custody or you surrender voluntarily?
No, other cases I have arrested in 2015.
Or taken on remand in this
Yes,
case?
Lordship.
Since when?
2015 I was arrested and in 26/2017 I was remanded in particular case, Lordship.
This particular case?
Yes, Lordship.
Okay, what is the date?
26/2017.
26/2017. Okay. So now what is the position of the trial?
Position trial, Lordship. Trial may be flagrant the trial because one police officer they have not attended the court. And repeatedly someone has been issued by the trial court. Public officers has not cooperated the trial, Lordship, and because he is in custody last 7 years, Lordship, in custody, Lordship. In the same footing, Lordship, other co-accused persons.
Wait, just a minute. डेट भूल कले अपन डेट होची 6/6/2019 रे अपन को एदरे रिमांड रे नहीं आई दैट इज द लेटर व्हिच हैज बीन रिटन बाय द लर्निंग trial court. Okay, so now what is the position?
Trial has not been completed, Lordship.
So if it is your first bail application,
Yes, Lordship.
And you say that most of the witnesses have been examined.
Yes, Lordship.
So where is the deposition copies?
Deposition copy I have not received.
Then
So,
how
Lordship,
can
because he has the member, no one member have supported to me to any
how
support.
can I know that the witnesses have not supported the
Because
proceeding?
because the lawyer of a lower court, trial court lawyer has I have contacted the trial court lawyer and he has stated some witness has been examined in trial court, Lordship. That is only important.
No, if you express your difficulty, I can call for the deposition copy from
Yes,
the
Lordship.
trial court. You said that I am not in a position to. It's all right. All right. The learned counsel for the petitioner submitted that he has received instruction What is the case number? Tell me.
That's ST case number 100 of 2020.
He has received instruction that ST case number 100 of 2020, which is subjudiced in the Court of Learned Additional Session Judge Bhanjanagar. Some witnesses have been examined.
Yes, Lordship.
However, he is not having the deposition copies of the witnesses, and the petitioner is not also in a position to produce the same, and therefore the deposition copies may be called for from the learned trial. In view of submission, the learned trial court shall submit not only the status report of the case, but also the Xerox copies of all the witnesses, deposition of all the witnesses, examined so far. And on receipt of the same, the registry shall supply a set of deposition to the learned counsel for the petitioner as well as learned counsel for the state. For such purpose, the file be placed before the learned registered judicial, who shall send email to the concerned trial court for compliance. Yes.
Item 8.
108, my lord, that the other cases in which, my lord, the prayer is same, my lord, is posted to Monday. That is BLAPL number.
This Monday?
My lord, 8/22 of 2022.
The learned counsel for the petitioner submits that another connected case, that is BLAPL number
8/22 of 2022. My lord,
is posted to
it was
28 तारीख तो
again. No, 24 तारीख सोमवार, because it was listed but not reached.
Oh, 24th July 2023.
Not similar, but prayer is same. Accused same, prayer same, but two cases.
So list this matter
along with
say जो number ta koi do
8/22 of 2022. Much okay.
मेरे ठीक आगे बढ़ी दो है ना.
Item 9.
May I please, your lordship? This is the second round bail application. The earlier bail application rejected by your lordships.
BLAPL number?
It's number 1, BLAPL number 5615 of 2021. And it's number 2, BLAPL number 6513 of 2021 by common order dated 21/12/21.
Then what is this 9024 of 21? Another matter has come, that downloaded copy of BLAPL number 9024 of 21 at flag A. Who has filed that application? Shanatan Jena.
The other co-accused person. Other all co-accused person released on bail.
Just a minute.
Your lordship may kindly see the last order your lordship passed on 12/5/2023. Your lordship directed for the evidence of Sasmita Patra and Ashok Patra. Since the date was fixed on 18/5/2023.
What happened?
Yes, the
Pass on. Some copy diyandu.
again.
Ashok Patra.
Ashok Patra is PW6 and Sasmita Patra is PW5.
The informant is my father-in-law. Deceased is my elder brother-in-law. I know the accused. On 15/6/21 at about 7 p.m. near the sand heap of Ganesh Bari, the incident took place. At that time, I was sitting in front of my house. After hearing Allah, my father-in-law proceeded to the spot and shouted for help. I proceeded to the spot and found that the accused Bhagirathi Jena. Who is this man? Ether ki achandi. So Bhagirathi Jena was assaulting my husband Ashok, the Bhagirath Jena mane it now petition number
No,
one.
petition.
Petition number one.
My lord.
Yes.
Assaulting my husband Ashok Patra. Ashok Patra is the deceased, right?
No, my lord. Doitari Patra is the deceased.
Assaulting my husband Ashok Patra bara कहला.
Ashok Patra is
एटा
the
मु एटा Sasmita Patra ro evidence टा पढुछि.
Aଜ୍ଞା.
So with a weapon like cutlery for which he fell down on the ground, sustained bleeding injury on the head. Thereafter accused Bhagirathi Jena, again you, petition number one, assaulted my elder brother-in-law Doitari Patra on his head with cutlery, for which he fell down on the ground and sustained bleeding injury on the head. Thereafter the accused Bhagirathi Jena, again petition number one, caught hold of me and another accused Sahadev Das Jena, got the throat by Tamil Katta. The accused person so and so also assaulted us, for which we all sustained injuries on our body. I obstructed the accused persons to save my husband as well as elder brother-in-law, for which they threatened me to kill. Both the accused persons brutally assaulted me on my head by means of Tamil Katta. So more specific allegation is against Bhagirathi.
In their cross-examination, paragraph 4 kindly peruse that we after recovery we are discharged from medical on 18/6/2021. After 3 days of treatment, they got recovered. Thereafter, they discharged from
No, but what about the deceased? This very first line, accused Bhagirathi Jena assaulted my husband Ashok Patra on his head. Ashok Patra is Ashok Patra is who is the deceased in this case?
Doitari Patra.
Oh. Again the second line, accused Bhagirathi Jena assaulted my elder brother-in-law Doitari Patra. Doitari Patra is the deceased on his head with cutlery, for which he fell down. So other person's case are different, but how you will claim parity with the persons against whom no specific overt act has been attributed?
You allegation of Sahadev Patra against Ochi, say that medical documents show thorax part is totally intact. There is no sorts of injury at the neck part. Page 90.
Kaharo?
Doitari Patra postmortem report annex karaichi. Page 19 of my bail application. The thorax part is intact. There is no such injury at his neck.
Mr. Mishra, Doitari Patra is the deceased.
Yes, sir.
Right?
Right.
Okay.
And paragraph 4 is a category state. We all discharged from the hospital after recovery on 18th.
जोमाने इंजुर्ड ହେଇଛନ୍ତି ମୁଁ ତାଙ୍କ କଥା କହୁନି, ମୁଁ ଡିସିଜ୍ଡ କଥା କହୁଛି.
ସେ ଡିସିଜ୍ ବି ସେ after recovery discharge ହେଇଥିଲେ.
ହେଲା ଯେ ତାପରେ ମରିଗଲା ପରା, କେବେ ମଲା?
ସିଏ ତାପରେ ତାଙ୍କ ଫାଦର PW2 କହୁଛନ୍ତି ତାଙ୍କ ଚେଷ୍ଟ ପେନ୍ ରେ ପ୍ରୋବ୍ଲେମ ହେଲା ବେଳେ ହସ୍ପିଟାଲ ଆଡମିସନ ହେଲେ.
No, date of occurrence is 15/6/2021, right? Date of FIR
15/6/2020.
16/6 ତାପର ଦିନ ଅଛି 16/6/2021. Now
and they have discharged from the medical 18/6/2021.
deceased ହେଲା Doitari Patra. Discharge କେବେ ହେଲା?
18/6/2021. After 3 day treatment, they both, all the three, including Doitari Patra, they have discharged from the medical.
ତାପରେ କଣ ହେଲା?
PW2 ତାଙ୍କ ଫାଦର କହୁଛନ୍ତି ତାଙ୍କର କ୍ରସ୍ ଏକ୍ସାମିନ 7 ରେ due to problem in chest, they are again go for treatment. Thereafter, during course of treatment, they died.
କେବେ death କେବେ ହେଲା ultimately?
26/6/2021. PW2 is the father of the deceased and he is informant of the deceased. The paragraph 7 category pouch.
Yes, Mr. Mishra.
Yes, Madam.
ଯାହା ବି ଅଛି accusation that is against that
ଭାଗୀରଥୀ
ହଁ ଭଗବାନ alias ଭାଗୀରଥୀ ଜେନା ବାକି ଏଇ ଯୋଉ ଲୋକଟା ସହଦେବ ଜେନା ନାଁରେ ଯାହା ଅଛି ଅନ୍ୟମାନଙ୍କ ନାଁରେ ବି ସେଇଆ ଅଛି ଯୋଉମାନେ କି ଅଲରେଡି ବେଲରେ ଗଲେଣି
And there are 32 charged witnesses. Only 6 witnesses have been examined till date.
6.
6.
What is your period of detention?
But PW2, your lordship may kindly see PW2. The informant has stated categorically that the accused persons, namely Bhagirathi and Sahadev, assaulted to my son Daitari. So this is
that will run contrary to the evidence of PW5 and 6. You said on verification that they are these star witnesses and accordingly IIC ensure their attendance. Now they have been examined and both these eyewitnesses have stated that only Bhagirathi assaulted to the deceased by means of a kotari.
Yes,
so, yes, what is the date of custody?
Yeah, petition number 1 is the 17/6/2021 and petition number 2 is the 4/7/2021.
17/6/21. 2 is?
4/7/2021. And there are total 32 charged witnesses, only 6 witnesses has been examined.
That you have already said. The learned counsel for the petitioner submitted that petitioner number 1 is in judicial custody since 17/6/2021, 17/6/21, and petitioner number 2, the na likhibe, is in judicial custody since 4/7/2022.
21.
4/7/21. 4/7/21, and both the petitioners have been charge sheeted under section AU offense guda achi to 147 nahi likhi diyante 302 IPC and other offenses. As for the prosecution case, the occurrence in question took place on 15/6/2021 and the FIR was lodged on the next day, that is on 16/6/2021 by one Duryodhan Patra. And in the meantime, these 2 star witnesses of the prosecution have been examined and they are PW5, Sasmita Patra, and PW6, Akshay Kumar Patra.
Ashok Patra. Ashok Patra.
Ashok Kumar Patra. And both of them have stated that it is appellant that petitioner number 1, Bhagirathi Jena, assaulted the deceased Doitari Patra on his head with a kotari, for which he fell down on the ground and sustained bleeding injury on the head. The learned counsel further submits that though the deceased along with some of the injured persons were shifted to the hospital, but after treatment they were discharged from the hospital, and again on 18/6/2021, and again the deceased developed some complication for which he was taken to the hospital, where while undergoing treatment he expired on 26/6/2021. The Land Council further submits that some of the co-accused persons have already been released on bail, and in the trial court, out of 32 charge sheet witnesses, only 6 witnesses have been examined, and therefore the bail application of the petitioners may be favorably considered. Land Council for the And counsel for the state was provided with the copies of deposition of the witnesses, and after going through the same, he fairly submits that the main allegation of assault on the deceased Daitari Patra is against petitioner number 1, Bhagavan alias Bhagirathi Jena. Considering the submission made by the land counsel for the respective parties, the fact that there is no specific overt act of assault on the deceased by the petitioner number 2, Sahadev Jena, and further taking into account the period of detention in judicial custody and release of the co-accused on bail, I am inclined to release the petitioner number 2, Sahadev Jena, on bail, fixed terms and conditions. So far as the petitioner number 1, Bhagavan alias Bhagirathi Jena, is concerned, in view of the available material on record and the role attributed to the said petitioner, I am not inclined to release him on bail. Accordingly, the bail application of petitioner number 1 stands rejected, 2 is allowed. Since the appellants are in, since the petitioners number 1 is in judicial custody since 17/6/2021, and trial has commenced, the London Trial Court shall do well to expedite the trial and try to conclude the same by end of December 2023. The petitioner is at liberty to renew the prayer for bail if the trial is not concluded within the said period. Copy of the order be communicated to the London Trial Court for compliance. For such purpose, file be placed before the London Register Judicial. We will communicate the order by email. Yes. P2 allowed, P1 rejected. Trial to be concluded December 2023. Yes, next.
Item 10.
Your Lordship has called for the status report of the trial.
Status report. "27 charge sheet witness, 3 witnesses have been examined. What do you want? You are in custody since when?
Since 3/2/2021. 2/3/2021.
Any other criminal antecedents?
No criminal.
So let him go on interim bail. Or the London Council.
Twice he was granted interim bail by the trial court and surrender regularly in time.
The London Council for the petitioner submitted that the petitioner was taken into judicial custody on 2/3/2021 and he was granted interim bail twice by the London trial court. On what ground?
Wife's illness ground.
On the ground of wife's ailment, and he surrendered at right time. After availing the interim bail period. It is further submitted that even though where is that report? Trial has commenced, but only 3 witnesses have been examined out of 27 charge sheet witnesses. As per the order dated 16/5/2023, the London Trial Court has also submitted the status report, which is dated 22/6/2023, which indicates that out of 27 charge sheet witnesses, 3 witnesses have been examined. London Council for the State submitted that
there is no criminal antecedent
against the petitioner as per the instruction received. Considering the submission made by the Land Council for the respective parties, in view of commercial quantity of brown sugar seized from the petitioner in this case, while not inclining to release the and bar under section 37 of the NDPS Act, while not inclining to release the petitioner on bail on merit, but taking into account his period of detention and slow progress of the trial and conduct of the petitioner in complying with the earlier interim bail orders granted by the trial court. I'm inclined to release him on interim bail for 3 months. He shall appear before the London trial court on each date when the case would be posted for trial and shall not indulge in any criminal activities disposed of violation of any terms and conditions. Yes, next. This is item number 12. Okay.
Item 19 may have regularship. Here, my lord, petitioner is languishing the jail custody from 29/12/2019, my lord. More than, my lord, 3.5 years, my lord. Sir, initially, the case was registered under section 302/34 IPC, read with 25/27 Arms Act, my lord. And charge sheet was filed under section, my lord.
No, your bail application was rejected earlier by this court.
Your lordship directed to renew the prayer after examination of vital witnesses, my lord.
So what has happened now?
Vital witness, I have given also the last occasion to supply the copy of the vital witnesses.
8 witnesses have been examined and copies have been
Informant
supplied.
and wife of the deceased, as well as managing trustee, and where the other co-accused person was staying, those who have committed the murder, in which house they are staying, they have been
where is the
examined.
deposition copies?
My lord, I have
Deposition copy. You have handed over the copies.
Yes, my
to
lord,
Mr.
already handed over last.
So what evidence has come against
My lord,
you?
against the petitioner, so far as the evidence
This man's name is Rasbihari Das.
Rasbihari Das, my lord.
So who has stated against this man and what?
My lord, till today, my lord, nobody has stated anything against the present petitioner. Lordship kindly visualize.
There are eyewitnesses to the occurrence.
Eyewitnesses is wife of the deceased. She has also been examined at
As PW?
PW, my lord, 7, my lord.
7.
Yes, my lord.
She has not implicated you.
No, my lord. He has stated 2%
Just a minute, witness.
And on the confessional statement.
Wait. Mr. Mishra,
Hello.
you have gone through this deposition of this PW7 Chabirani Panda.
Yes, Usman.
She has not implicated the petitioner.
No.
Not identified also in court during trial.
Yes, ma'am.
Yes, Mrs. Jana.
Eight
Please use the mic properly. On ही नहीं.
May I pray one thing? जो PW8 does a confessional
My lord,
statement.
Wait, when she is making submission.
so far as PW6 is concerned, eyewitness to the occurrence, he doesn't have the knowledge because the deceased was killed by the supari killer.
Okay.
Supari killer. Your lordship may kindly see PW8.
PW8. Okay.
Statement of PW8.
Yes.
Paragraph 3.
3. Okay.
Yes. On 29/12 so while I was standing on the road near the Baliguda police station, the police Baliguda police station requested me to cooperate them in the investigation of the murder case of Abhimanyu Panda, asked me to come with them to the police station. Accordingly, I had gone to the Baliguda police station. I found accused Rasbihari Das.
This present petitioner.
Yes. Rasbihari Das and one Jason Nayak of Baliguda were present in the police station along with other police staff. In our presence, the accused Rasbihari Das confessed that he is involved in the murder case of Abhimanyu Panda and also confessed that he, along with K. Biswajit Patra, conspired to commit murder of Abhimanyu Panda and also procured 2 supari killer from Ganjam district to commit the murder of accused Abhimanyu Panda. Thereafter, your lordship may kindly turn to page para 8. Para 8 only he has stated, I know the accused Rasbihari Das about 10 to 15 years who is working in the electricity department. I do not know about his family members. Next, your lordship may kindly turn to.
And also I cannot say where the residence.
ଟିକେ ରୁହନ୍ତୁ ଆପଣଙ୍କଠୁ ମୁଁ କଣ ନ ଶୁଣିକିନି ଅର୍ଡର ପାସ୍ କରିଦଉଛି ବ୍ୟସ୍ତ କଣ ପାଇଁ ହଉଛନ୍ତି ସେ କହିସାରନ୍ତୁ. Yes.
ଆଜ୍ଞା. Next, your lordship may paragraph 14.
14. Yes.
Paragraph 14 towards last, there are 4 to 5 police staff along with Jason Naik were present near Rasbihari Das. I along with Jason Naik were in a close distance with Rasbihari Das during recording of his statement. Police has recorded his statement in writing, but I cannot say his name. Name of that police. Next, your lordship may kindly 15, para 15. I do not recollect whether police has recorded my statement on that day or not. I do not recollect who others have signed the confessional statement of the accused except accused Rasbihari Das, Jason Naik, myself. Para 16. It is not a fact that the accused Rasbihari Das has not given his confessional statement before the police in my presence. It is not a fact that no recovery was made from the accused Rasbihari Das in pursuance to his statement.
What recovery was made?
Recovery of a motorcycle was made from which was used to show the supari killer the house of the deceased.
Okay.
And it was recovered. So the next page also it is
that
not.
That means it's a 27 Evidence Act statement that was recorded, and in pursuance of such statement, that motorcycle was seized. That motorcycle was used when the supari killers were shown the house of the deceased.
Oh,
That
super,
is it.
he has, and apart from it, some other he has also there is a transaction, money transaction. So far as supari killers are concerned, that abhika mo pakhe nahi.
Okay. Yes, what is your submission now?
My respectful submission is that my lord confession that his statement to lordship on to cross examination page 13, my lord, paragraph 13.
No, your earlier bail application was rejected in 2185 of 2020.
Yes, ma'am. For examination of after.
Just a minute, let me see that. Yes. All right. Make your submission.
Yes, my lord. He has categorically stated on 30/12/2000, paragraph 13 on 29/12/2019.
Paragraph.
PW paragraph 13, my lord. He has stated on 30/12/2019, police has examined me, and prior to that day, police has not asked anything about the case. I cannot the same of the police who has called me to the police station on 30/12/2019. But your lordship kindly see, he has stated he has not been examined. But initially, your lordship, at the first instance, he has examined on, my lord, on my lord 10/12/2019, my lord. Your lordship, he has stated like this, my lord, more name so and so, my relevant portion, ଅଭିମନ୍ୟୁ ପଣା ଜଣେ RTI applicants ଥିବା ବେଳେ ବହୁତ ବଡ଼ ବଡ଼ ଲୋକଙ୍କର ଦୁର୍ନୀତିରେ ପଦାର୍ପଣ କରିଥିଲେ। ମନ୍ଦିର କମିଟି
Mr. 10/12/2019 incident, he has also stated in his chief examination in para 2. Yes. But in that incident, he has not stated anything against you.
And also in 29/12,
he said that 10/12 ghatana hala. I came to know that some miscreants have committed murder, but not stated anything against you in this paragraph 2. Your complicacy started from paragraph 3, as pointed out by Mrs. Jana.
My lord, in 29/12/2019, she has also been examined.
Who?
S.K.SAHOO.
Yes, sir.
He has stated also the petitioner has not confessed. He has stated like this.
All right.
ମୁଁ ସକାଳେ ମାର୍କେଟରେ ଥିଲାବେଳେ ଆପଣ ପୋଲିସ ବାବୁଙ୍କୁ ତନ୍ଦତରେ ସାହାଯ୍ୟ କରିବେ ବୋଲି ପଚାରିବାରୁ ମୁଁ ରାଜି ହୋଇ ଆପଣଙ୍କ ସହ ଗଲି। ଇଲେକ୍ଟ୍ରିକ ସାହିର ରସବିହାରୀ ଦାସଙ୍କ ଘରେ ଚଢାଉ କରି ତାଙ୍କୁ ଅଟକ ରଖିବା ସହ ଅଭିମନ୍ୟୁ ପଣ୍ଡାଙ୍କ ହତ୍ୟାକାଣ୍ଡରେ ରାସବିହାରୀ ଦାସଙ୍କ ମୋଟରସାଇକେଲଟିକୁ ବ୍ୟବହାର କରୁଥିବାରୁ
apart from this case, any other case is pending against this?
No,
No, sir.
Are the learned counsel for the petitioner, learned counsel for the state, as well as learned counsel for the informant. The learned counsel for the petitioner submitted that the petitioner is in judicial custody since 29/12/2019, and he has been charged sheeted under section 302, 120B109 by 34 of the Indian Penal Code. The petitioner earlier approached this court for bail in BLAPL number 2185 of 2020, and as per order dated 11/11/2020, the bail application was rejected. However, liberty was granted to the petitioner to renew the prayer for bail after examination of material witnesses. Learned counsel for the petitioner submitted that in the meantime, 8 witnesses have been examined in the trial court, including the widow of the deceased as PW7, and no clinching evidence has come on record, and the petitioner is having no criminal antecedent, and therefore the bail application may be favorably considered. Learned counsel for the state, on verification of the case diary, fairly submits that the petitioner is having no criminal antecedent. he placed the evidence of PW7 Chabirani Panda, the widow of the deceased, from which it appears that she has not stated anything against the petitioner. The learned counsel for the informant, Ms. Jena, on the other hand, opposed the prayer for bail and contended that Supari killers were utilized for killing the deceased Abhimanyu Panda, and the house of the deceased was shown to the Supari killer, and for that purpose one motorcycle was used, and the said motorcycle was seized at the instance of the petitioner, basing on his statement recorded under Section 27 of the Evidence Act, and in that light, PW8 has S.K.SAHOO has stated about the same. Considering the submission made by the learned counsel for the respective parties, the nature of acquisition, the nature of evidence adduced so far, the period of detention of the petitioner in judicial custody, I am inclined to reconsider the prayer for bail and direct the petitioner to be released on bail. Petitioner shall appear before the London trial court on each date when the case will be posted for trial. He shall not try to tamper with the evidence and shall not indulge in any criminal activities. Violation of any terms and conditions shall entail cancellation of bail. Yes.
With my lord's permission, my lord, item 33, similar matter, rather the petitioner is standing in better footing. Item 33 today.
33. Your period of detention?
The same thing, Lord. That is, my lord, 29/12/2019.
That was also earlier rejected.
Yes, your lordship, that is in BLPL number.
এই লোকনার भी কিছু নাই মিস্টার মিশ্র এই जो एस बालाजी आचार्य नार भी কিছু নাই এই जो 8টা সাক্ষী जो प्लेस कले से
I have to verify, my lord, because I
okay
My lord, informant senior is appearing for the informant.
No, he has not verified. That file doesn't belong to that matter. Will be taken off when it reaches. Don't. It might have been entrusted to somebody else. How will do that file? Yes.
Item 15, may I praise your lordship? My lord, the item kindly be passed over.
Pass over, it will be taken up some other day. What do you want?
My lord, the matter kindly be taken up some other day.
Some other day. All right. Urgent the matter. Yes. Yes.
May I please your lordship? My lord, the petitioner is in custody.
This is your second application. Wait. Let me see the earlier order. 4779.
My lord, that is, I have filed the order. This page
It's a commercial quantity of ganja.
192 kg, 150 gram.
It was rejected and direction was given to conclude the trial within
Minor.
6
Minor.
months. What is the position now?
Four witnesses have been examined from the side of prosecution, my lord. I have already given the deposition copies. Now I have already filed one interim petition, my lord, that is on the ground that the petitioner's mother is suffering from thyroid cancer, my lord. So I have filed
Any document you filed?
My lord. The medical report and all other things I have filed.
Mr. Mishra,
Yes,
have you received the copy of the interim application?
Yes.
762 of 2023.
My lord.
762.
Have you taken instruction?
No.
Okay.
No order is passed.
Take instruction. The IN number 762 of 2023. This is an application for interim bail on the ground of ailment of the mother of the petition. Medical document has been annexed. The London Council for the State has received the copy of the interim application and seeks some time to obtain instruction put of this matter. गोटे सप्ताह छाड़ दियंतु तापर सप्ताह अर्थात 4 तारिख रे रखि दियंतु 4th अच्छा in the meantime also the status report be called for है ना
मानो date fix
4 तारिख पूरा कहली
cancer patient को CPMT बेचता
but your the instruction has to be taken from Chhattisgarh.
Minor.
So it will take some time, yes.
4th August, my lord.
4th August 2023.
My lord obliged.
Item 17, I prefer a Passover, my lord.
Passover or you want it some other day?
Passover.
Okay, you have received the case diary?
Yes.
Okay, Passover.
May I please, my lords? In this case, your lordships kindly have a glance, my lord. Annexure 1, my lord, that is the
earlier rejected. Yes,
my lord. 1919 of 2021.
What is the last bail application? How many times you have approached this court?
Good time, my lord, information.
1919. Okay.
Information.
It was rejected by. Okay. Disposed of by Justice Narsim, but then why it has come before me? Earlier application might have been dealt by me.
The 3-4 bail application, lordships of co-accused, lordship granted bail by this Honorable High Court. But bail number I have with my lord, but whether that bail application disposed by lordships or by my lord any other judge, I know. All 4 accused persons co-accused are already released on bail. Petitioner only accused, which custody my lords.
I have granted bail, but the observation is like this.
Two criminal antecedents of similar nature, one criminal antecedent.
That the main allegation is against one Jittu Swine.
I am for the Jittu Swine, my lord. In the meantime, what happened, my lord? Trial progressed, my informant, my lord, who was the brother of the deceased, my lord. He has also stated, my lord, that that is a false case. Police jack wale muse FIR likhi dechi, my lord.
No, what is the evidence?
My lord, I have already submitted copy, my lord, to state, my lord. Last occasion, lordship directed to serve. I serve kar deji. Lordship's copy, lordship's.
Just a minute. As it appears that the ST case number is 104 of 2020. In annexure 2 is the rejection order.
My lord.
So how many witnesses have been examined in the trial court?
My lord, so four witnesses have examined, my lord, including the informant, who is the brother of the deceased. Who, your lordships kindly have glanced to
Have
the.
you supplied deposition copies?
Yes, madam.
Which witness have stated, Mr.
Well,
Nagansi?
last witness was examined on 7/9/2022. So in the meantime, 4 witnesses would have been examined.
Hinadi.
My lord, they just the lordships.
See, that PW4's evidence was recorded on 7/9/2022. So in the meantime, almost 10 months have passed. What he says that whether no other witness has been examined in the meantime.
My information, my lord, lordships have kindly have a glance to the informant, just what he has stated, my lord. He is the scriber of affair, my lord. Yeah, I may permit to read, my lord, to the PW number 4, my lord. I am the informant in this case. I know the accused Jitendra and Gangadhara. I do not know the other accused persons of this case. This is Santosh Kumar Biswal is my younger brother. He died about 4 to 5 years back. On that day, I was in my
You
house.
are reading whose evidence?
The informant evidence, that is PW number 4. I have supplied copy, lordships.
Yes.
What do you mean, my lords?
Yes.
I am the informant in this case, my lord. I know the accused Jitendra and Gangadhar. I do not know the other accused persons of this case. This is Santosh Kumar Biswal is my younger brother. He died about 4 to 5 years back. On that day, I was in my house. When I heard that my younger brother Santosh Biswal was shot and was brought to our house in injured condition, we shifted him to CSC Gobara. He was sent to MKCG Barampur and thereafter to SC Medical College Cuttack, where the succumbed to his injury. Thereafter, I lodged a written report in PS. This is my report marked as exhibit such and such, is my signature thereof. Inquest report of the dead body was conducted in my presence. Inquest report was prepared where I have given my endorsement. This is the said inquest report marked up as exhibit such and such. In my endorsement comes signature thereof.
Since when you were in custody?
My lord, petitioner custody में लड़ से remanded 20/6/2020 में cross examine में लड़ the informant says, your lordships, para 3, I cannot say the contents of the affair. I have got no idea regarding this scribe of affair. I signed on the same at the instance of police. I gave endorsement on the inquest report at the instance of the police. The accused persons are not involved in this case.
1999 কোন অর্ডারটা আছে ওইটা উইথড্র করে ডিসপোজ অফ করে আর দি লার্নিং কাউন্সিল ফর দি
Here, your lordship may kindly see that one Monu Biswal is the eyewitness. Actually, informant is not the eyewitness.
Informant lordship kind FIR 1 টা দেখুন পড়ুন
মন্নু বিশ্বাল
Monu Biswal. He is the eyewitness, my lord, and he has stated categorically that this present petitioner was holding a single shot pistol and fired to the deceased.
That Manu Biswal has not been examined.
No. That apart, my lord, he is having 2 numbers of CA. Out of 2, 1 is also under section 302.
Or then let me call for the report. The learned counsel for the petitioner has produced the deposition copies of 4 witnesses, from which it appears that PW4 was examined on 8 PW4 ଟା 8/6/2023 ରେ ପୁରା ହେଇଛି ଏବେ ଆଉ ତାପରେ କୋଉଠୁ ଆଉ ହେଇଥିବ 8/6/2023 ତା ନା କଣ ସେ ଯୋଉ ୱିଟନେସ୍ ନା କହୁଛନ୍ତି
ମନୁ ବିଶ୍ୱାଳ
ତାର କିଛି ଆଉ ଇଏ
ନାୟନା ନାୟକ another is Noina Naik.
ସେ କଣ ଆଇ ୱିଟନେସ୍
Yes, eyewitness.
Manu Biswal has been examined as PW2. Turned hostile. Noina has been examined as PW3, turned hostile. Heard the learned counsel for the petition, learned counsel for the state submitted that The petitioner is in judicial custody since 26/2020. And in the meantime, trial has commenced, and star witnesses on behalf of the prosecution have been examined, and they have stated nothing against the petitioner. Even the informant has also not supported the prosecution case. The deposition copy filed by the Land Council for the petitioner is taken on record. Land Council for the state oppose the prayer for bail, considering the submission made by the Land Council for the respective parties. Period of detention of the petitioner in judicial custody, since material witnesses have not supported the prosecution case during trial, I am inclined to release the petitioner on bail. Allowed.
Obligement. May I please, Your Lordship? My Lord, Your Lordship, last occasion, Your Lordship directed to the Learned State Council to examine and inform whether any, apart from the examined 8 witnesses, any other material witnesses left out, my Lord.
Yes, Mr. Mishra.
The report has not come.
No, not report. You are to verify the case diary. 8 witnesses have been examined.
Yes,
he has filed the deposition copies.
Yes,
Now, if no other material witness is there, then we will see that what these 8 witnesses have stated against the petitioner. That is to be seen. Instruction মানে report কোଣ ଆସିବ এই 8ଟା ସାକ୍ଷୀ ଯୋଉ ହେଇଛନ୍ତି, have they stated anything against you?
No, my Lord.
No
They
one.
have not stated anything about the petitioner. There is no eyewitness. Depend upon the circumstantial evidence.
So what is your custody date?
Custody, my Lord, recently he was arrested on 7/2/2022.
7/2/2022.
My Lord. Previously he was arrested and Your Lordship granted interim bail, which he was not followed. Then his bail application was dismissed, my Lord.
No, after 7/2/2022.
He is in custody.
He,
And
no,
split of trial taken and 8 witnesses examined.
What are the offences under which charge sheet submitted?
364, 302, 201, 120B, 34 I.
364, 302, 364,
364, 302, 201, 120B,
and 34 IPC.
34.
My Lord.
Your earlier bail application was rejected in BLAPL number?
2274 of 2022, my Lord.
এটা বার করো, double. Double 274 ওটা 74 of 2020. সে অর্ডারটা আছে কি আপনার ঘরে?
No, my Lord.
Okay. Custody since 7/2/2022 has been charge sheeted under section 364, 302, 201, 120B by 34 of the Indian Penal Code. You are granted interim bail.
Yes, my Lord.
In the earlier case.
Earlier case, my Lord.
The petitioner
remained absconder for about 5 years, my Lord.
No.
My Lord, he was granted an interim bail in 5512 by 2016.
Earlier. Acha. That means ବର୍ତ୍ତମାନ 7/2/2022 ପରଠୁ ଆଉ ଆପଣ ବେଲ୍ ଯାଇନାହାନ୍ତି ତ? After the petitioner, acha, initially you are on bail, right?
Yes,
ତାହେଲେ ଏମିତି ଲେଖି ଦିଅନ୍ତୁ. The petitioner was initially granted interim bail for a period of 15 days, which was extended to another 20 days as per order dated 22/9/2017 in BLAPL number 5512 of 2016. but after availing the interim bail period, he didn't surrender. Whereafter, he was taken into judicial custody on 7/2/2022. The learned counsel for the petitioner submitted that the trial has commenced in the meantime and 4 witnesses have been examined.
Eight witnesses.
Eight witnesses have been examined
47.
out of 47 witnesses, and they have not stated anything against the petitioner, and the case is based on circumstantial evidence. And therefore, the bail application may be favorably considered. Learned counsel for the state, on the other hand, submitted that since the petitioner was an absconder for
and having
one criminal antecedent, he should not be released on bail. Considering the submission made by the learned counsel for the respective parties, the nature of evidence adduced so far in the trial court, and the period of detention of the petitioner in judicial custody, I am inclined to release the petitioner on bail subject to furnishing 2 local sureties, 50,000 each, and he shall appear before the learned trial court on each date when the case would be posted for trial, and shall not indulge in any criminal activities, and shall not try to tamper with the evidence allowed. Next.
Please, your lordship.
20. Yes, Mr.
Lord,
Pandit.
I am virtual.
Yes, yes.
I filed a petition, my lords, for modification of your lordship's orders granting bail to the petitioners.
Which
My lords,
order I
this is
granted
order
bail?
that 19/5/2023.
What modification you want?
Your lordship had directed both petitioners to deposit the cheated amount. Firstly, at the time of going out on bail, 25% of the respective amounts in respect of both of them, and thereafter the balance was to be deposited, my lords, in 6 equal monthly installments. Now, my lords, we have furnished bail bonds, but we are not in a position to furnish cash security, my lords. That is because of the fact, my lords, that there has been an attachment by the bank of the assets of the petitioners. I have enclosed the surfacing notice, my lords, as annexure 4 to the IU. So we have furnished bail bonds, but we still remain in custody. And I leave it to your lordship.
Unless there is one condition regarding furnishing cash surety.
Yes, my lord.
So that is why. So, Mr. Misra, you take instruction and to this on this interim application, you say that the entire property has been attached, all these things. Take instruction. Have you received the copy of that interim application or modification?
Yes, sir.
Take instruction and ask the IO to file an affidavit, if any, whether the averments taken are correct or not. Because if he has nothing, how can he furnish it? So you file it by next week. We'll calculate. This IA number 862 of 2023. This is an application for modification of the order dated 19/5/2023 relating to furnishing cash surety as a condition precedent for grant of bail. The learned counsel for the state has received the copy of the interim application and wants to obtain instruction and file an affidavit of the investigating officer. List this matter. I'm keeping it to 4th, Mr. Panda, and you will supply the copy in advance to Mr. Panda. Okay? All right. 4/8/2023. Objection, if any, be filed in the meantime.
May I please?
May I please?
Yes, Mr. Patnaik.
My lord, 20B2C of the NDPS Act, my lord. And I have filed an interim application that is 383 of 2023, lords.
For interim bail?
For interim.
On what ground?
My lord, health of the mother of the petitioner, my lord.
Have you given a copy to the?
Yes, my lord.
You have obtained instruction. এটা বাহার করো এই যে 383 কপিটা। You are a man from?
Local person, man, Malkani district.
The report is against them.
Inviting the reference to the certificate, I am to honor that son. I have received the instruction from the genuineness of this answer. The patient obtained a ticket but did not attend the orthopedic department. Instead, he went to a private clinic. Dr. S.K.SAHOO wrote his prescription on the OPD tickets of the government hospital, violating the rules of the government. Prabhu Dhanesh is not a government doctor in this. He has been engaged as a doctor. Dhanesh has submitted a certificate to the undersigned in response to the letter that he has examined the patient in his private clinic. So it's a forged one.
Forged document.
Yes. The doctor is not a government doctor. The prescription,
my lord,
was of the orthopedic department of the government hospital. So your client took that what is that ticket?
OPD ticket, madam.
OPD ticket.
My lord.
So he did not. He was not treated in the orthopedic department. That OPD ticket was taken and it was shown to a private doctor. His name is S.K.SAHOO. And S.K.SAHOO filled it off as if he was a doctor attached to the OPD.
And he is a dialysis doctor and given advice of different disease, madam.
May I permit to withdraw, my lord?
OPD ticket रे केमती प्राइवेट डॉक्टर टा लिख दउतला पूर्ण करिन हां ताको आनी ना आपण फाइल कर देले बेल पई
आदिवासी लोक ସେମାନେ ଜାଣିନଥିବେ
ଆପଣ ସିନା ଜାଣିନଥିବେ ସେ ଡାକ୍ତର ଜାଣିନଥିବ ଯେ ମୁଁ ଗୋଟେ ପ୍ରାଇଭେଟ ଡାକ୍ତର ମୁଁ ଗୋଟେ ଗଭର୍ଣ୍ଣମେଣ୍ଟ ହସ୍ପିଟାଲର ଓପିଡି ପ୍ରେସକ୍ରିପସନ ରେ କେମିତି ପୂରଣ କରିବି the Learning Council for the IA number so and so. This is an application for interim bail. The Learned Council for the petitioner, Learned Council for the state has obtained instruction from the IIC Chitrakunda police station in the district of Malkangiri, which indicates that the patient obtained a ticket from OPD on dated 12/2/2023 for orthopedic department, but did not attend either the orthopedic department OPD nor the ONG department OPD as per record. On the other hand, she went to a private clinic of Dr. S.K.SAHOO, and Dr. S.K.SAHOO wrote his prescription on the OPD tickets of the government hospital, violating the rules of the government. And Dr. S.K.SAHOO is not a government doctor of the hospital, and has been engaged as a doctor for dialysis unit by Rahi Care Private Limited, bracket outsourcing agency. Dr. Dhaneshwar Sahu has submitted a certificate to the registered administration SLN MCH Koraput to the effect that he has examined the patient in his private clinic. The report furnished by the Learned Counsel for the state is taken on record. In view of such report furnished, the Learned Counsel for the petitioner doesn't want to press this application. Accordingly, IS stands dismissed. The inspector in charge of Chitrakonda police station is at liberty to proceed against Dr. Dhaneshwar Sahu in accordance with law. Copy of the order be handed over to the Land Council for the state. Bail application. You want to argue this today or you want to adjournment?
Kindly urge.
The Land Council main bail application 250 of 2023. Land Council for the petitioner 6 for an adjournment. Adjourn. Yes.
Obliges. May I pray one thing else? Kindly call for the trial report, status report.
Status report be called for, yes. Obliges.
Free copy, madam.
Free copy of the order.
Item 25, my lord. Ijon petition come at flag A, my lord. Notice.
प्लग ए रे कौन देखिए निवेदन अभिप्राय है कि जे समान शोषण जदि विचाराधीन अछि किंतु okay he wants now to engage Mr. Niroj Kumar Singh.
Yes.
You are Niroj Kumar Singh. Have you filed your wakalatnama?
Yes, ma'am.
Okay, you can argue the matter. There is no problem.
My lord, I will engage my Lord and
It's all right.
May I please?
So, you have got the case diary, Mr.
No,
Das?
C has not come.
Well, it's
CD has not come.
CA.
Oh.
in the
Actually, has not come. CD.
Yes. May I permit to one thing? My lord?
It's a commercial quantity and
Yes. 14/11/2019 he is on custody. My lord. In the meanwhile, out of 12 charge sheeted witnesses, 5 have already been examined. My lords. I have supplied my lord today. My lords.
Is a man from Bihar.
Yes, my lord.
So you obtain also the instruction about the this address verification. Let it. The Learning Council for the petitioner filed the deposition copies of some witnesses which are taken on record. Copies of the same also supplied to the Learning Council for the state. It is submitted that the petitioner in judicial custody since Kebedu
14/11/2019.
14/11/2019, and in view of the delayed disposal of the trial, the petitioner may be granted bail. The Learning Council for the state submit that the petitioner is a man from state of Bihar as per the address furnished in the cause title, and he may be given some time to verify about the authenticity of the address. Let the Superintendent of Police Koraput make necessary communication with the Superintendent of Police Ara Bhojpur in the state of Bihar and obtain written instruction whether the address furnished in the cause title is a correct one or not. List this matter, good saptah for free copy of the order be handed over to the Land Council for the state. The name of Miss Adya Sri Mishra will not be reflected in the cause list henceforth. Yes.
That's great.
Yes, Mr. Das.
May I please, Your Lordship? The present petitioner, who is inside.
This is earlier bill application rejected.
Not rejected, but rejected, and thereafter Your Lordship granted 3-month time interim.
What is the last time you are granted 3 months bail?
That is 4358 of 2000.
43?
Sorry, 3933 of 2022.
That number is not here in the 3933. Okay,
Mail.
so that order 3933. Oh, the bail was granted on 2/9/2022.
Mail.
That was for 3 months.
3 months. He has surrendered in time. And the present petitioner, who is inside the custody more than 3 years, near about 4 months. 15/3/2020.
No. You said that you have been released on 3 months.
Minus kale 3 ବର୍ଷ ହେଇଗଲା.
No. ଆଉ ତା ପୂର୍ବରୁ ଯାଇନଥିଲେ?
ନା. ଦିଥର ନା ଥରେ.
ଗୋଟେ ଥର ଯାଇଛନ୍ତି ନା କେତେ ଥର ଯାଇଛନ୍ତି? Rejected expedited.
6/9/2022.
No, that order I have seen, already seen. What is the position now?
Till today, that trial is going on. My Lord, last occasion, Your Lordship also called for a report.
Status report.
Status report is there.
Status report of the Status report ମଗାଇଥିଲା କି? ବସିଯାଉଛ କଣ?
Status report ଟା ଥିଲା।
ଘର କଥା କହୁଛ ନା?
Annexure।
So accused so shifted to produce. You are Santosh Kumar Bagarti. Santosh Kumar Bagarti was released on interim bail on 6/9/2022. Did not appear on completion of the period of interim bail, for which non-bailable warrant of arrest was issued against him on 5/12/2022.
He has surrendered.
He surrendered on 20/12/2022.
2022. That is there.
So 15 दिन आपण
15 दिन my lord.
Yes.
That is there. I have got that certified copy also.
Mr. Das, ସେ 15 ଦିନ ସେତେବେଳେ ଅଧିକା ରହିଗଲେ ବର୍ତ୍ତମାନ 2 ମାସ 15 ଦିନ ଦିଆଯିବ। Heard the Learning Council for the Petitioner Learned Council for the state. The Learned Council for the petitioner submitted that ସେ ଆଗ ଅର୍ଡରଟା ଟିକେ ଦେଖିଲେ। The petitioner it's a previous bill application order. The petitioner was taken into judicial custody on 15/3/2020, and he was directed to be released on interim bail for a period of 3 months as per order dated 2/9/2022. BLAPL number in BLAPL number 3933 of 2022, and he has received instruction that the prosecution case is not yet over, and therefore the bail application may be favorably considered. Status report furnished by the Learning Council for the trial court indicates that the case is now posted for dated example 25/4/2020. The case was posted for examination of the informant and executive magistrate. However, it is mentioned that the petitioner was supposed to surrender on 5/12/2022 as per the interim bail order granted by this court, but he surrendered on 20/12/2022 after issuance of non-bailable warrant of arrest against him. Learned Council for the state opposed the prayer for bail, considering the submission made by the Learned Council for the respective parties. Period of detention of the petitioner in judicial custody, the progress of the trial so far, I am inclined to release the petitioner on interim bail for a period of 2 months and 15 days. Local surety de debe. Yes, disposed of. Next.
With her lordship's permission, the lordship wanted that one judgment. Apart from this case, fellow, that is the judgment of the apex court, 2 years, half month. That is 37 is not a bar.
No, that's all right. No, I will. You want I reject that you have flouted the terms and conditions.
ନାଇଁ ନାଇଁ
Yeah.
ଆପଣଙ୍କୁ ଦେଇତା ମାଗିଥିଲେ ଗୋଟେ
Yes, next.
ଆର୍ଚିବିଲା ସେଇଥିପାଇଁ ଦେଇଛି 3 month ପାଇଲା
Mr. Manas Kumar Chand.
Item number 28, I pray for an adjournment, my lord. 29.
Okay, who is appearing for the informant?
I am
You are
appealing for
there.
the informant.
So you have received the case diary?
Ma'am,
Okay.
29, madam.
29.
Ma'am.
So learning council.
That means also trial already commenced.
No, status report has come.
Aye.
Flag A.
Aye.
What is the status report? देखिए. Flag A. Out of 41 charge sheet witness, 4 witnesses have been examined. That is the report of April. All right. I'm just giving that whatever the learned counsel for the petitioner seeks for an adjournment. It appears from the status report dated 21/4/2023 of the learned trial court that out of 41 charge sheet witnesses, 4 witnesses have been examined. Let the learned counsel for the petitioner obtain the certified copy of deposition of all the witnesses examined so far in the trial court and supply copy thereof to the learned counsel for the state. Yes, Arjun.
My lord, I'm through virtual mode.
Yes.
Lordship. Lordship, the applicant accused in jail from 7th of March 2021. 2 are on regular bail and 1 was on interim bail by the for the 3 months by the order passed by this court.
But this
Lordship,
is only one accused has filed this BLAPL.
Yes,
That
Lordship.
is Sumit Saharan.
Yes, sir.
Okay.
Yes, Lordship. I am for the Sumit sir.
Uh-huh.
Lordship, my submission is 2 are on regular bail, 1 is on interim bail, and Lordship, there he is in JC from 7th March 2021. So almost 2 year 5 month of judicial custody. Out of 16 charge seated witness, only 1 has been examined. So seeing the long judicial custody, I pray.
What is the report? Let us see that.
On the last date of hearing, your
Yes,
Honor has
the report has come, which indicates that out of 16 charge sheet witnesses, 2 witnesses have been examined.
Okay, Lordship.
Okay, have you verified the address?
No, well, not found.
Furnish. And you furnish the 2 local sureties, Mr. Manohar?
Not yet.
No, you furnish the details,
Okay.
the names, address, and the documents, ROR copies, etc., so that you will verify the same.
Yes, Lordship. I will submit today only.
Okay, peruse the status report dated 22/6/2023 of the London Trial Court, which indicates that out of 16 charge sheet witnesses, 2 witnesses have been examined so far. Mr. Manohar London Counsel submit that the petitioner is in judicial custody since 7/3/21.
March.
7th
Yes, Lordship.
March 2021. The London Counsel for the state submitted that the petitioner is a man from Haryana and he may be given some time to verify whether the address furnished by the petitioner in the cause title is correct one or not. Let the superintendent of police.
Previous order is there.
Lordship, address has been verified.
Oh, acha, order is there then
Yes.
Okay.
Lordship, on the last date of order, Lordship, I directed for
So
verification.
that you want to take some time. London Council, then London Council for the state submits that though earlier an order was passed for verification of the address, but some more time is required for that purpose. So let the London Council for the petitioner furnish the names, address, and documents of 2 local sureties who are interested to take the petitioner on bail to the London Council for the state, on receipt of which the same shall be verified through the inspector in charge of which police station case it is?
Malkangiri.
Naima?
Malkangiri.
It is Mathili police station. A free copy of the order be handed over to the Land Council for the state. Supply these details of the
Yes, Lordship.
sureties. Okay.
Yes, Lordship. Obliged, Lordship.
It will come on, my lord.
It will come on 4/8/22.
My lord, in this 21C.
Please use the mic properly.
In DPS 21C, in this case, the involvement of the petitioner is the as per who is apprehended by the STF. He disclosed the name in his evidence. He disclosed the present petitioner procured the brown sugar from the from that person. As per the version of accused person, the present petitioner is involved in this case. Nothing has been seized and recovered from his person, and FR does not disclose the name of the present petitioner.
You are in custody since when?
Since my lord charge sheet submitted, and
I'm telling you, since when you are in custody?
Mm, 23/11/2022.
23/11.
23/11/2022.
22. Charge sheet submitted under section
21C/29.
21C and 29.
29. Showing as abscond of this charge petitioner.
Nothing was recovered from you.
Nothing was recovered. Only the version of the co-accused person.
You have received the case diary, Mr.
No, I not received. Let it be next week. I'll get it.
All right. The learned counsel for the petitioner submitted that except the confessional statement of co-accused before police, there is no other material against the petitioner who is in judicial custody since 23/11/2022. The learned counsel for the state seeks for an adjournment to obtain the case diary and also instruction about the criminal antecedent, if any, against the petitioner. Put up this matter. It will come next week, Mr. All right. Place this matter on 28th July 2023. Mr. Bhansdo.
Praise the Lord.
Yeah.
Status report.
Status report was called for at flag B. Okay. I am to submit that the case record in so-and-so split up file arising out of. No, it's the original case is of the year 2015.
Yes, he was arrested on 16/3/2020.
On 16/3/2020, the record was committed against him to the Court of Session Judge Board. On so-and-so, the case record was received by this court on transfer from the Court of Session Judge Board. However, due to non-availability of the original case record, hearing could not commence. Original case record in ST number so-and-so was received from so. Now the case is posted for hearing.
Initially, your lordship granted interim bail. I have surrendered in right time.
When?
Your lordship on.
What is that BLAPL? In which you are?
2022 surrender करती.
No. In which BLAPL you are granted interim bail? What is the BLAPL number?
BLAPL 2810/2021.
देख ले बोर्ड आउट ऑफ 3810.
3810.
That order was passed on 9/9/2022.
Right time,
and you sought for an extension also.
That was not.
That was not So did you surrender at?
Yes, my lord. 16/12/2022 ରେ. In the rejection order also surrender କରିଛି. ମୋର certified copy ବି ଅଛି.
Anand. So are the Land Council for the petitioner and counsel for the state? Yes, Mr. Das, let him go on interim bail. The Land Council submits that the petitioner, after availing the interim bail period of 3 months, as per the order dated 9/9/2022, passed in BLAPL number 3810 of 2021, surrendered at right time. And he produced the certified copy of the surrender certificate, which is taken on record. The status report furnished by the London Trial Court indicates that on account of non-availability of the original case record, the trial couldn't commence. And now the original record has been received. In view of such state of affair and hearing the London Council for the respective parties, since the petitioner has not flouted the terms and condition of the earlier order, interim bail order, I'm inclined to release him on interim bail for 3 months. Yes.
3 months disposal.
3 month disposal.
Main application disposal. Main disposal.
Sabut, huh?
What is it?
Yes, that matter.
Yes.
He was. I released one of the accused.
Yes.
His name is, what is that name?
Rasbihari Das.
Rasbihari Das. And in that case, he submitted the deposition copies of 8 witnesses. So similar footing, or it is anything different?
Different footing, because the person, those who have stated about the his involvement have been declared hostile.
Okay.
And
जे से 8टा भीतर से माने यही जानते
1 and 2.
1 and 2 से जो यार ऑर्डर टा देखी देबे रासबिहारी दास रो है ना ताको देखिए नहीं से डेट ऑफ कस्टडी सेम
yes your lords on 30/2019
ताको देखिए लिखिए डेट ऑफ कस्टडी टा सेम अछि बाकी जा रीजनिंग भी आइछि से भी सेम अछि है ना सब लिखा है डिटेल
Other condition
आइटम नंबर 13
13
रासबिहारी दास रो जा ऑर्डर है शेयर कर देबे है ना
condition my lord, that will be met.
कंडीशन भी जोटा रही सेटा रहिबो आउ ये it also main witnesses examined so far as the petitioner is concerned PW 1 and 2 and they have not supported the prosecution. Yeah. The deposition copies filed in the connected bail application which was disposed of today, that is BL 8 April लिखिए कारण दीटा गोटे सेट दीजन तो all right allowed. Next.
Pledge your lords.
Yes, Mr. Patnaik.
My 20B2C of the NDPS Act, my lord. But in this case, my lord, first bail anticipatory bail has been disposed by the Honorable Justice S. Pujari, and other cases has been disposed by the Honorable Justice Dr. S.K. Panigre.
No, এটা হচ্ছে ଯୋଉଠି କି ମୁଁ ଏଇ particular accused ମୁଁ ଆଗୁ ରିଜେକ୍ଟ କରିନି ତ
ନାଇଁ first ABLAPL 15846 of 2019, that is anticipatory bail, that has been rejected by the Honorable Justice S. Pujari.
No, leave it. About the regular bail application.
Regular bail application, first bail application has been allowed by the Honorable Justice Dr. S.K. Panigre.
What is that number?
That is, my lord, BLAPL 7333 of 2020, Your Lordship.
But some bail application, one bail application of the year 2019 is also there.
No, that is anticipatory bail.
No. BLAPL anticipated.
Yes. My lord, BLAPL 8794 of 2019 that has been rejected by the Honorable Justice S.K. Panigre on dated 2/9/2021, my lord.
So that was the earliest one.
No, BLAPL 7333 of 2020, that is 1/9/2021.
ସବୁଠୁ ପ୍ରଥମ
1/9/2021 ଏଇଟା 2/9 ରିଜେକ୍ଟ ହେଇଛି।
नो केबे रिजेक्ट ହେଇଛି ସେଟା ନୁହେଁ କେବେକାର ବେଲ ଆପ୍ଲିକେସନ ନା କେବେ ରିଜେକ୍ଟ ହେଇଛି କାହାକୁ ଦିଏ କହୁଛ ଡିସ୍ପୋଜ ଅଫ ଡେଟ୍ तो डिस्पोज ऑफ फर्स्ट बेल एप्लीकेशन दा
ऑनरेबल जस्टिस एसके
दैट इज इन बीएलएपीएल नंबर
7333 of 2020
जोटा अर्लियर डेट रिजेक्शन हेतो से उन जाई जीवो ए ऑर्डर ता देई जी द लॉ एंड काउंसिल फॉर द पिटिशनर submitted that this is the first bail application of the petitioner. However, as per this is ACG High Court, the first bail application in connection with this case, which was disposed of, is BLAPL number
7333 of 2020.
7333 of 2020 on kebe
disposed on 1st September 2021.
1/9/2021 by Honorable Justice S.K. Panigre. In view of such submission, the registry shall place this matter before appropriate bench.
Highly obliged.
Yes. First bill application.
Yes, ma'am.
I would have used so Royji.
And I have supplied a copy. Co-accused order.
No. Your bail application was earlier rejected by me.
I am not verified.
It
was my lord has allowed on one of the co-accused, my lord.
अरे co-accused no मु फास्ट आपण प्रथम प्रश्न मु पचारुची पिटिशनर एटा प्रथम बेल एप्लीकेशन ना आगुरु आस्तिला सेटा को आगे उत्तर दियंतु this BLAPL number 1775 of 2023 the name of the petitioner is a single petitioner.
Yes, my lord.
Okay, his name is Julia alias Donesor Lenka. Take care. Okay, I disposed of one bail application of a co-accused. His name is Akhila Kumar Sahu. BLAPL number 5971.
Yes, my lord. And subsequently, my lord, 8668 of 2022. I'm supplying the copy, my lord. Kindly have a
3912 on the bench. That is the latter order. So I have held, considering the submission made by the Land Council that the petitioner is in judicial custody since he is having a jewelry shop and it is alleged that he received some gold ornaments from a co-accused, at whose instance the police recovered the gold ornaments from the petitioner, and that the case against the petitioner might come under section 412 of the Indian Penal Code. I granted bail.
Another co-accused who is standing on the similar footing.
So what are the materials against you?
He is, my lord, he has been identified in the TI period. And so also
identified in the dock, my lord,
So,
by PW1 and 2.
how do you claim parity with a man who has been against whom the material is 412? ଆପଣ ମାନେ ଜିନିଷ ନେଲେ ଘରୁ ତାକୁ ଦେଲେ ସେ ରିସିଭର ଅଫ ପ୍ରପର୍ଟି ଥିଲା ତେଣୁ ତାକୁ ବେଲ ଦିଆହେଲା ବଟ୍ ୟୁ ଆର୍ ଦି ପର୍ସନ who committed डकैती and you have been identified in the TI period as well as in the court during trial. And how many criminal antecedents you have got? How do you say that you are claiming parity with this man?
And there are several bail applications are there, my lord, which was disposed by the
अरे एमाने जो माने को बेल दिया है एमाने कौन TI period आइडेंटिफाई थिले अब कोर्ट आइडेंटिफाई थिले
my lord, kindly have a running page 3, my lord. 3 of bail order.
Learning counsel for the petitioner submitted that petitioners are in judicial custody since 19/8/2020 and similarly situated co-accused persons have been released on bail and he has no criminal antecedents also. Filed the deposition copies. Okay, learned counsel for the state after going through the evidence of the witnesses submitted that PW1 and PW2 not only identified the petitioners in the test identification period but also in the trial court. However, on verification of the case diary submitted that the petitioner is having no criminal antecedent, the case diary doesn't reflect overall. Okay. Any criminal antecedent, Mr.
No, I have to, not in the CD, madam.
कारण सीटर आपण इंस्ट्रक्शन नहीं थिले नहीं कि सबमिशन करते नो क्रिमिनल एंटीसीडेंट
मगाई नहीं
Okay, the learned counsel for the petitioner files the copy of the bail order of the co-accused persons, which is taken on record. The learned counsel for the state submit that though he has received the case diary, but instruction about the criminal antecedent of the petitioner is awaited. Release this matter on 28th of July 2023.
May I please, my lords? This is the petitioner's second journey to my lord's
What is
court,
the
my
last
lords.
order? Last order is dated?
My lords, in BLAPL number 880 of 2019, my lords. 13 January 2023.
No, first so the report টাকে দেখুন এটা ফ্ল্যাগে এটা এই কেসটা 1953
Petitioner is behind bars for more than 8 years and 3 months, my lords.
The report indicates that out of 16 charge sheet witnesses 12 witnesses have been examined, 2 have been declined and 2 witnesses including the IO are yet to be examined and the case was posted to 11/4/23. Now that period has already over. So what has happened in the meantime?
Because thereafter, no other witnesses have turned up, my lords. What happened in this case, my lords? The petitioner has one more criminal antecedent, in which case a coordinate bench of this honorable court was pleased to grant him interim bail for a period of 10 weeks, my lords. Due to the pendency of the present case, he was not able to avail the same, my lords. I have supplied the copy in the said order. And behind bar for more than 8 years and 3 months, my lords. was never released, neither on interim. Initially, case under section 392, thereafter 395 and 2527 of the Arms Act.
So many cases are pending against you.
In that respect, Lordship, I am filing an affidavit sworn by the brother, my lords. There are these, apart from these two cases, he has been acquitted in the other two cases, my lords.
You are using arms and ammunition, and those are seized from you, and
those two old cases, if Lordship may go through the recitals of the affidavit, my lords, in the second paragraph mentioned, Barongo PS case number 94 of 2001 and Barongo PS case number of 78 of 2010, my lords, he has been acquitted. And
those cases were also under section 302 of the Indian Penal
no,
Code.
that is the antecedent in respect of which I have supplied the order copy, my lords. That is Barongo PS case number 51. Admittedly, it is a case of under section 302. But a coordinate bench of this honorable court was pleased to grant him interim bail in that case, my lords, for 10 weeks. He has not availed, and that order reads, my lords, since the date of actual release, my lords. I humbly pray, my lords, lordship may grant me 10 weeks interim bail, my lords. More than 8 years, 3 months behind bars.
Mr. Tripathi?
Yes, my lord. There are 3 criminal antecedents, my lord. Not 2.
Dita achi se gote kare ye rani. The
2 of them 302.
He was granted interim bail by the coordinate bench for 8 weeks. Now, this order was passed on 6/2/2023. He
10 weeks, my lords. That is. It is 10 weeks, my lords.
But he could not avail the same. What is his submission? Because this case is also there. So, no, in the rejection order, number of cases have been reflected. So, out of those 3 cases, 1, 2, 3, all these 3 cases are pending.
My lords. No, my lords. 2 have, he has been exonerated. That I have reflected, my lords, in my affidavit, Barango PS case number 94 and Barango PS case number 78 of 2010. In both the cases, he has been exonerated.
Exonerated means no charge sheet submitted.
No, my lords. After completion of trial, he has been acquitted. I am sorry.
Have you filed the
copies?
That comprehensive affidavit?
Lordship, I have. Apart from the present,
have you given the copy to the State Council?
I have given, my lords.
Mr. Tripathi, have you got this copy of the comprehensive affidavit?
In court right now. Comprehensive affidavit copy.
Affidavit made. Order.
No, it's affidavit.
Yes, sir.
Come to the affidavit and the rejection order, page 13. In the rejection order, the London Trial Court has reflected about 3 cases to be pending against. That is also your instruction.
Yes.
And out of those 3 cases, in 2 cases,
acquitted.
That is 94 and 78, he has been acquitted. So the only case that is pending is 51 of 2023.
In which he has been granted interim bail.
He has been directed to be released on bail
51
by
is
coordinate bench.
51 is under 302.
Right, he has been granted, but he could not avail the same because this present case is pending. What he says that in that case I have been granted 10 weeks, so let this case also be 8 weeks. 8 weeks bail will be granted so that I can come out. Otherwise, the Learning Council for the petitioner submitted that the petitioner was taken into judicial custody in connection with this case since
6/4/2015.
6/4/2015. And in the meantime, in the trial court say eta kora status report again. In the trial court, out of 16 charge sheet witnesses, 12 witnesses have been examined, and the case is lingering as the prosecution is unable to close its case by examining the witnesses. And therefore, the bail application of the petitioner may be favorably considered. Peru, the status report dated 27/3/2023 of the Lannan Trial Court, from which it appears that out of 16 charge sheet witnesses, 12 witnesses have been examined, 2 witnesses have been declined by the prosecution, 2 witnesses, including the IO, are to be examined. Stop. The Lannan counsel for the state pointed out from the rejection order that there are 3 criminal antecedents against the petitioner. The land counsel for the petitioner has filed a comprehensive affidavit wherein it is indicated that in 2 of the cases, the petitioner has been acquitted. The affidavit filed in that respect is taken on record. Stop. So far as the other case is concerned, that is Barang PS case number 51 of 2013, the London Council for the petitioner has produced the bail order dated 6/2/2023, which shows that the petitioner was granted interim bail for a period of 8 weeks. Number BLAPL number 11503. The London Council submits that in spite of the bail order of the petitioner passed in BLAPL number 11503 of 2022 as per order dated 6/2/2023, he could not come out of the jail custody since since in this case he has not been released on bail, and therefore the bail application may be favorably considered. Land counsel for the state opposed the prayer for bail. Considering the submission made by the land counsel for the respective parties, how many witnesses have been examined so far?
12.
And who has stated against you?
In the present case, no,
Yes.
none of them have supported.
Yes, Mr.
Yes.
Supplied copies also. Unit senior members. None have supported.
All right, take down. Considering the submission made by the London Council for the respective parties, going through the amendments taken in the application, the comprehensive affidavit filed, and since the petitioner has been granted interim bail in the connected case for a period of 8 weeks, which he could not avail, I am inclined to release the petitioner on interim bail for a period of 8 weeks. बाकी जहाँ यादेर जहाँ terms and condition अच्छी शेयर रखी देवे. Yes, great.
Disposal.
3 months are disposed of. 3 months bail granted.
And mention matter item 145.
Yes.
145 I had mentioned in the first hour that interim bail.
What purpose? You want interim bail?
The wife of the petitioner is ill, she requires treatment, and also your lordship consider the.
Have you obtained instruction in 145? Mr. Mishra, 145 has been allotted to whom?
Not allotted.
File has not come. They were not expecting that 145 will be taken up. You should have earlier intimated him.
First hour I had mentioned 10:30. May I pray your lordship on this matter Monday, Tuesday, and the supplementary?
No. That's a separate day. That's other matters are that cause
Let-
list. Printing of cause list of Monday, Tuesday is already over.
28th and the supplementary list is
It will come on 28th. Yes, call the next matter. 37, Mr. Dwivedi.
My lord, I am appearing for the informant in this case.
So he has filed an application for interim bail. You have received the case diary?
Yes, sir.
Okay, pass over.
The interim bail infrastructure.
Why?
That is for marriage of his son. my lord. That is over and
486 of 23. Let us see that. Marriage of the son of petition number
Yes,
1.
yes. That is over 7/4/23 ରୁ ଗଲାଣି.
All right, IN number 486 of 2023. This is an application for interim bail on the ground of marriage of the son of petitioner number 1, which was going to be solemnized on 9/4/2023 as per the averments taken in the interim application. Land Council for the state submitted that by efflux of time, the interim application has become infructuous since marriage of the son of petitioner number 1 has already been solemnized. In view of such submission, the IA is disposed of.
My lord, I am appearing for informant.
The Mr. Abhijit Patnaik, Land Council, is present for the informant. So, list this matter urgent kar diyo. Baki IA ta dispose of kar diyo. Main case urgent. 38
May I please?
Which one is your earlier bail application?
2440. 2040. Dispose of 13/5/2022.
2040. ऑर्डरটা ভার করে দেখিয়ে। Hmm, 302. In view of the evidence of the witnesses adduced so far in the trial court and the nature of gravity of the accusation, while not inclining to release the petition or direct the London trial court to make every endeavor to conclude the trial by end of December 2022, if the petitioner is at liberty to renew the prayer. Yes. So what is the status now?
My lord,
Status report. Asila status report indicate করছি the accused Deepu alias Deepak Naik is in custody since 24 to 2020, charge framed, and he was granted interim bail. He was directed to surrender on 4/2/2022 within court hours. As such, the accused handed over surrender before this court on so and so. In the meantime, 6 numbers of prosecution witnesses, including the informant, have already been examined. Summons have been issued to the rest charge sheet witness, and the case is posted to so and so. But this is a very old report, that is 10/5/2022. So
a fresh status report moving forward.
পুরোনাটা বহু। Have you obtained the deposition copies?
Yes, madam. In the meantime, out of 32, 10 examined. 6 was
Just a minute. 30
30 out of 32, 10.
Then give the copy to the state council, or you have given it?
No, Miller.
File a set of deposition for the court also.
Madam.
The London Council for the
status report maybe.
Okay, the London Council for the petitioner submits that he is having the deposition copies of 10 witnesses. 10 witnesses. Let the London Council for the petitioner supply the copy of the same to the London Council for the state, and also file a set of deposition for the court. From the deposition sheet, it appears that the last witness, that is PW10, was examined on
1/11/2022.
1/11/2020. 2020.
11/11/2022.
11/11/2020. Since more than 2.5 years have passed. In the meantime, let a status report be called for, and from the London Trial Court, and for such purpose, file be placed before the London Registered Judicial. So it will come a week after, along with the status report, and you supply the deposition copy to the State Council and also for the court.
By Monday.
Okay, by Monday tal kore diyo.
Date.
ଗୋଟେ ସପ୍ତାହ ପରେ ପରା କହିଲେ ଶୁକ୍ରବାର ତ ଆସିବ ନା ମ୍ୟାଟର, ତେଣୁ
Last of the notes directed to the jailer for the custody certificate, my lord. Already, my lord, I have filed the deposit copy to the State Council.
Okay, just a minute. Mr. Tripathi.
Yes, Miller.
You have received the deposition copies?
Only 2 deposition. 1 and 2. Well, people 4 and 5 already have filed, man.
Ajan date, how many witnesses have been examined?
Only 5 numbers. So out of
5 witnesses. And you have annexed only 2. PW1 you have annexed, then PW2. Any further? 3 is there. 4 and 5? File it. So, is it there? Okay. So, these 5 witnesses, out of which one has conducted post-mortem examination, that is PW5. So, the rest 4, 1, 2, 3, 4, have they stated anything against you?
No, my lord. I would say Lakshmi Tudu, my lord, mother of deceased.
Who is it? PW?
PW3, my lord.
All right, let us come to PW3. PW3 Champa Singh.
Yes, she is not to eyewitness.
PW2, my lord.
PW, you said. Just a minute. PW2 is Lakshmi
Tudu.
Lakshmi Tudu.
My lord, mother of deceased.
That is annexed to the bail application. PW2,
Yes.
PW2 evidence ko asantu. He is a eyewitness to the occurrence.
Yes.
I do not know the informant. I know the accused standing in the dock, who is my husband. The deceased, Santosh Singh, was my son. The incident took place on 11/3/2019 at about 11 p.m. in my house. At the time of my incident, myself, my deceased son, and my husband were staying in the said house. On that night, my husband returned to our house after driving. On small matter, quarrel ensued between us, and the accused beat me. I had married earlier to Sanjay Singh and was blessed with a son, namely Santosh Singh. When Sanjay started beating me, I left him with my son and married to the accused. Okay. On the date of incident, due to our quarrel, accused killed Santosh by throwing him on a cement wall of our house. Due to such assault, Santosh sustained bleeding injury on his head and fell down. On the ground, the accused gave kick to Santosh, stand up on the stomach of my son, vomited and died at the spot. So it is stated you are that man.
My lord, page 32, my lord. So, she has stated that I have not examined by the police and I have not lodged the FIR. And my son was died due to taking the poison food and dead. My lord, para 4, my lord, page 32. In cross, yes, my lord. Police is the
It's not a fact that I have not stated. I have stated.
I have stated before the IO on Bharatin Unishi that my deceased son was sleeping after consuming food and that he vomited and that we took him to hospital where he died.
এইটা পুলিশ স্টেটমেন্ট ইয়া থিলা বলি সে কହୁଛି ସଜେସନ ଦିଆଯାଇଛି ଯୋଉଟାକୁ ସେ ଡିନାଏ କରୁଛି
Para 5, my lord. She was not examined by police, my lord. And
I have not informed about the incident to the neighbors. I cannot say. Is it there, Mr. Tripathi?
Yes, sir.
You eyewitness ର ତାର 161 statement ରେ paragraph 4 ବିଷୟରେ ସେ କହିଥିଲା ଦେଖିଲେ?
No. 164 statement is there. Married?
ତାକୁ ସଜେସନ ଦିଆଯାଇଛି ଯେ ତମେ ପୋଲିସ ପାଖରେ କହିଥିଲ 12/3/2019 ତାରିଖ ଦିନ ତମର ପୁଅ ଯେତେବେଳେ ଶୋଇଥିଲା ମାନେ ଖିଆପିଆ କରିକିନି ସେତେବେଳେ ହଠାତ୍ ସେ ବାନ୍ତି କଲା ଏବଂ ତମେ ତାକୁ ହସ୍ପିଟାଲ କୁ ନେଇଯାଇଥିଲ ଯୋଉଠିକି ତାର ଡାକ୍ତର ମୃତ୍ୟୁ ବୋଲି
That is very question. I am reading that 164 statement.
ଏଟା କୋଉଠୁ ପାଇଲେ ତାକୁ ପଚାରିଦେଲେ ସେ କେମିତି ବି ରେକର୍ଡ କଲେ ମୁଁ ଆଶ୍ଚର୍ଯ୍ୟ ହେଉଛି
17/10/19 ଅଛି statement ରେ.
Yes.
Second time examine 17/10/19 ମାନେ ଅଛି ଆଉ
How can you confront such a statement if it is not there in 161 statement? You are asking
it 164. 164 statement रे भी नहीं से.
No, say that how it has been stated, how it is been permitted by the court and also the APP, what he was doing there, the public prosecutor, whosoever it may be. Unless in terms of 145 of the Evidence Act, you are permitted to put the confrontation, make the confrontation about the previous statement reduced to writing. But if this statement is not there in the 161, how can you confront?
Once police has examined on 17 October, after 12/3/19 ମାଇଲର ଦିଥର ଆଜ୍ଞା କରିଛି ସେଇ ତାରି ଉପରେ ଆଜ୍ଞା ସେ କହିଛି ଯେ ମୁଁ ସେତେବେଳେ ମନା କରିଥିଲି ମୋ ପୁଅ ସେ ଆଜ୍ଞା ମରିଥିଲା ଫୁଡ୍ ପଏଜନିଂରେ ମୁଁ ଆଜ୍ଞା ମୁଁ କହିନି ମୋ ସ୍ୱାମୀ ମାରିଛି ବୋଲି 17/10/19
ଆପଣଙ୍କର ତାର ଚିଫ ଏକ୍ସାମିନେସନ ରେ ସେ କଣ କହିଲା? ଚିଫ ଏକ୍ସାମିନେସନ ରେ କହିଲା ଯେ କଳି ଆମ ଭିତରେ ହଉଥିଲା ଆଉ ସନ୍ତୋଷ ମୋର ଯୋଉ ପ୍ରଥମ ସ୍ୱାମୀର ପୁଅ ହଉଛି ଡିସିସ୍ଡ, ତେଣୁ ସିଏ ମୋ ପୁଅ ସେଠି ଥିଲା, ଇଏ କଣ କଲା ରାଗିକିନି ତାକୁ ଗୋଟେ ସିମେଣ୍ଟ ଚଟାଣ ଉପରେ ଫୋପାଡି ଦେଲା ପରେ ସିଏ ତାର ମୁଣ୍ଡରେ ଆଘାତ ହେଲା, ତାପରେ ତାକୁ ଗୋଇଠା ମାରିଲା ଏବଂ ସିଏ ଗୋଇଠା ମାରିକିନି ତାର ପେଟ ଉପରେ ଛିଡା ହେଇଗଲା। ତେଣୁ ମୋର ପୁଅ ବାନ୍ତି କଲା, ବାନ୍ତି କରି ସ୍ପଟରେ ତାର ଡେଥ୍ ହେଲା। ଦ୍ୟାଟ ଇଜ ଦି ଏଭିଡେନ୍ସ ଇନ୍ କୋର୍ଟ।
ସେ ମନା କରିଛି ମୁଁ ଯାଇନି ପୋଲିସ ପାଖକୁ, ପୋଲିସ ଜଣେ ଜନ୍ମ 17/10/19
Police statement is there, 164 is there. Mere statement that I had not gone to that would not. What about the 164? Can he say that he has not gone to the magistrate? Yes, read out the statement.
Yes, madam. I am reading that relevant portion. ତାପରେ 2017 ମୁଁ ଦାଶରଥୀ ଟୁଡୁକୁ ବାହା ହେଲି। ସେ ମଧ୍ୟ ମତେ ବିଭିନ୍ନ ସମୟରେ ଟିକେ ଟିକେ କଥାରେ ମାରପିଟ କରେ। ମୋ ପୁଅକୁ ମଧ୍ୟ ସେ ବାଡାଏ। ମୋ ସ୍ୱାମୀ ଡ୍ରାଇଭର କାମ କରେ। ଗତ ମାର୍ଚ୍ଚ ମାସ 11 ତାରିଖ ଦିନ ସେ ଖୁବ୍ ମଦ ପିଇ ଆସିଲା ଏବଂ ମତେ ବାଡେଇଲା। ସେଇ ସମୟରେ ମୁଁ 7 ମାସର ଗର୍ଭବତୀ ଥିଲି। ମୁଁ ବିରୋଧ କରିବାରୁ ମୋ ପୁଅ ସନ୍ତୋଷର ମୁଣ୍ଡକୁ କାନ୍ଥରେ ପିଟି ଦେଲା ଓ ତାକୁ ଗୋଇଠା ମାରିଲା। ତାପରେ ଦାଶରଥୀ ମୋ ପୁଅ ପେଟ ଉପରେ ଚଢିଗଲା। ପୁଅ ବାନ୍ତି କଲା। ମୁଁ ଦାଶରଥୀକୁ ଅନୁରୋଧ କରି ପୁଅକୁ ଡାକ୍ତରଖାନା ନେବାକୁ କିନ୍ତୁ ସେ ନେଲା ନାହିଁ।
Exact statements he has given.
Yes.
He is an eyewitness because nobody else was present. It took place within the four corners, within the four walls of the house. So he is the star witness on behalf of the prosecution, supported the case and how her son died.
Page 26 inquest report, which was signed in interest of the eyewitness matter. ମୋର ପୁତୁରା ସନ୍ତୋଷ ସିଂ ଗତକାଲି ରାତିରେ ଖାଦ୍ୟ ଖାଇ ସାରିଲା ପରେ ଝାଡା ବାନ୍ତି ହୋଇ ମରିଛି, ଏତେ ସନ୍ଦେହ ନାହିଁ ମ୍ୟାଡମ୍। Page 26 ମ୍ୟାଡମ୍, inquest report stated by the other witness ମ୍ୟାଡମ୍ in presence of the eyewitness Lakhin Tudu ମ୍ୟାଡମ୍ who has signed on the inquest.
That is not the thing which is to be required to take into consideration at this stage. Yes, Mr. San, you are in custody since when?
16/10/2019, 16th October 19.
How many witnesses total have been examined?
Total 5 numbers examined out of 10.
This trial commenced in 2020. And once you go there, you will create problem for that lady who has deposed against you as PW2.
Yes.
No, my lord, she had left to her. Already she had left to her father's house.
You should obtain that. The star witness on behalf of the prosecution is none else than the wife of the petitioner who has already been examined as PW2 in the trial court and stated about the commission of murder of his son by the petitioner. Land counsel for the petitioner submits that PW2 is now not staying in the house of the petitioner. Have you got any instruction where she is staying? And she is staying at her father's place. Land counsel for the state seeks some time to obtain instruction in that respect. And he is having no CA, no criminal antecedent.
No, sir.
The Learned Counsel for the state, however, submitted that the petitioner is having no criminal antecedent. List this matter. Next week, आनिबा खाली तो आनिबे एतिके और तो बाप घर रोची ना ये रोची अब. So list this matter on 28th July 2023. Yes. That's all for today.
I may be pardoned, my lord. Item number 88, my lord. It is earlier rejected by Honorable Justice S.K.SAHOO. There is one earlier application, BLAPL number 5821 of 2021. Item number 88, my lord. Malaya Kumar Barik.
Malaya Kumar Barik, is it the first application or earlier rejected?
Earlier rejected, my lord. Earlier rejected by Honorable Justice S.K.SAHOO.
What is that number?
That is number is BLAPL 5821 of 2021.
So take down item number 88. The Learned Counsel for the petitioner submit that the earlier bail application of the petitioner in BLAPL number 5821 of 2021 has been disposed of by Honorable Justice A.K. Mahapatra. A.K. Mahapatra?
Yes, madam.
This matter along with sworn so before appropriate bench with the approval of the Honorable Chief Justice.
My lord, one item 44, my lord. Item 44, earlier rejected by my lord Justice Sasikant Misra. That is BLAPL number 11058 of 21.
Which one? Item number?
44, my lord.
44.
I have given the memo to that.
No, at earliest value
No, my lord, that is a wrong number. Has been your lordship has first one Prem Kumar Agarwal you rejected, but this matter has been gone to that bench for which
no, Dilip Kumar Sharma's bail application, if it has been rejected by the other bench, it will go to that bench.
Yes, I have given a memo to that.
The Learned Counsel for the petitioner files a memo indicating therein that the earlier bail application of the petitioner in BLAPL number
11058 of 21
has been rejected by Honorable Justice
Sasikant Misra on dated 27/7/2020.
Place this matter sponsor before appropriate benches with the approval of the Honorable Chief Justice.
Pardon to mention item 46, same my lord. My case, my application was also earlier rejected by Honorable Justice.
Kamalaro reject
reject certificate ଦେଇଛି ସେ ଅନ୍ୟ 6553 2022 सर्टिफिकेट अदर कोई जो बेल एप्लीकेशन आसी सेटा हुजूर बेल ଦେଇଛନ୍ତି
ନୋଟିସଟା ଟିକେ ଦେଖିଲ ନମ୍ବର ଅଛି କି ସେଟା ତାଦେରେ କ୍ଲିୟର ଲେଖା ହେଇଛି ତ ଯଦି ରିଜେକ୍ସନ ହେଇଥିବ ଅର୍ଲିୟର ଯୋଉ ବେଞ୍ଚ ସେଠିକି ଯିବ ନଚେତ ଯୋଉ ଫ୍ରେଶ ବେଲ ଯଦି ଫାଟିଲା ତାହେଲେ ସବୁଠୁ ପ୍ରଥମ ଯୋଉଠି बेल डिस्पोज ऑफ ହେଇଥିବ ସେଇଠି ଏୟା ତ କ୍ଲିୟର ଓକେ ତାହେଲେ ଲେଖି ଦିଅନ୍ତୁ ମିଷ୍ଟର Jafrullah Learned Counsel for the petitioner submit that the
item 46
pura that the earlier bail
accused को हजूर ଦେଇଛନ୍ତି बेल
no, that is not that the earlier bail application of the petitioner has been disposed of by
Honorable Justice V. Narasimha.
Justice B. Narasim in BLAPL number
6553 2022.
6553 of 2022. Place this matter along with so and so before the appropriate bench.
Pardon to make a mention, madam. My lord, item number 59, my lord. 59, 59, my lord. My lord, 376.3, they are noticed to be issued.
Just a minute. 59.
My lord, BLAPL 6032 by 2020.
Okay, you serve an extra copy?
Yes, my lord.
The Learned Counsel for the petitioner submits that one of the offense is under section 376(3) of the Indian Penal Code. Extra copy to be served, baki usual order kar deve. No? Extra copy.
Pardon your lordship, item number 75, my lord.
3 IPC notice to be served. Yes, item number
75, my lord. Earlier disposed by Honorable Justice S.K. Panigrahi.
Yes,
the matter twicely disposed by Honorable Justice Panigrahi.
75. This Adil Muhammad.
My lord, BLPL number 1827 of 2022. Previous bail application number are 5417 of 2020 and 4780 of 2021.
These are all by Honorable Justice Panigrahi.
Yes, Your Lordship.
And what about 717?
So Your Lordship granted bail to the another co-accused.
Oh, no, that is not the criteria. But Adil's Mohammed bail application was dealt by Justice Panigrahi.
Yes, Your Lordship.
All right. The Learned Counsel for the petitioner submitted that the earlier bail application of the petitioners in BLAPL number 5417 of 2020 and 4780 of 2021 were disposed of by Honorable Justice S.K. Panigrahi, list this matter along with so and so for assigned bench with the approval of the Honorable Chief Justice. Yes.
And pardon, Lord, item 226 I had mentioned past our Lord.
226, what do you want?
This is the application, my Lord, I have filed on interim application, my Lord. NBW has been issued in this case.
Just a minute.
This is the revision of the year 2008, my Lord.
226.
Lordship. Only I pray, my Lord, next week in the supplementary list that will suffice.
What is this application for? CRL or EB?
This is a revision, my Lord, against that 319 petition and 2008 application. Stay was there, but after the Asian resurgence, my Lord, that was vacated. And two of them, one is arrested and one is released on bail. Thereafter, these three petitioners are there. So in the meantime, my Lord, they didn't know that this application has been filed. Then NBW has been issued against the present petitioner along with two others.
Okay, we'll take up next week.
Only I pray, my Lord, supplementary list, let it come next week. That is my sole prayer, so that it can reach the board.
এই যে টাইপ র দেখো 224 ম্যাটার দেখো সেই টাইপ র যদি কিছু ম্যাটার থিব কোন সুইটেবল ইনস্ট্রাকশন কোন ওটা লেখা আছে হ্যাঁ হ্যাঁ আচ্ছা ছাড় দিন
My Lord, item number 132. Earlier rejected by my Lord Justice S.K. Mishra. Shashikanta Mishra, my Lord.
Just a minute.
132. My Lord.
This petitioner name is Tufan Behra.
My Lord.
Tufan Behra's earlier bail application
Rejected
is
by my Lord.
no BLAPL number account.
BLAPL number, my Lord.
Then how can there are about 20 bail applications mentioned here. So
Tufan Behra was earlier rejected by my Lord Shashikanta Mishra.
132 টা বার করো The earlier bail application is 7648 of 2022.
My Lord.
That was rejected by acha ta purburu ଆଉ ଗୋଟେ ଥିଲା 9344 of 2020. Verify. Maybe that 9344 of 2020, that was the earliest one. ବୁଝିଲେ?
My Lord.
9344 ଟା ବାହାର କଲେ କି କାହା ପାଖରେ dispose of ହେଇଛି 9344. Acha, then it will go. The Learned Counsel for the petitioner submitted that the earlier bail application of the petitioner in BLAPL number 9344 of 2020 has been disposed of by Honorable Justice Shashikant Mishra. List this matter before the appropriate bench with the approval of the Honorable Chief Justice.
Lordship, item 234, my Lord, there is a noting that steps for limitation not taken. Since last week, I have already taken the steps. Lordship,
item number
234, my Lord.
You have already taken?
Yes, my Lord. In fact, there is no delay. Still then, I have taken steps.
The Learned Counsel for the petitioner submits that steps for limitation has already been taken. Registry shall verify and place the documents filed by the Learned Counsel for the petitioner on the next date. which is fixed to give the date.